You have no reason to be. Are we ready to start? Is everybody here? All right. Okay. Let's see. Good morning, Advocate Tassim.
Good morning, Deputy Chief Justice.
How are you this morning?
I'm very well, thank you. And you?
I'm good, thanks. Are you ready to run?
I'd like to think so.
Okay. Don't worry, you're in a safe zone.
Thank you.
We'll take good care of you. You were born in the KZN.
Yes, I was. It's a funny story. But I left there when I was 3 months old, so I'm not sure that I'm really from Natal, but that's where I was born.
But, okay. You hold 2 degrees, a Bachelor of Arts and an LLB from VETS.
That's correct.
Okay. You started out as an attorney.
Yes, I did. I think I did my articles in 1991, and those years we had to do 2 years of articles, which was a wonderful thing. I benefited from that, yes. So it was for 2 years of an articles, and then I practiced for just a little under a year, I believe.
All right. And then you decided to go to the bar.
Yes, I did.
All right. Where? In Pretoria?
Well, that's also a story. I'm from Pretoria. I did my university, I attended university in Johannesburg. I did articles in Pretoria. I did pupillage in Johannesburg, and I came back to Pretoria to practice.
All right.
So I did pupillage at the Johannesburg bar, yes, and returned to Pretoria shortly after the completion of pupillage.
Okay. And you're still in Pretoria?
I still live in Pretoria, yes.
How long have you practiced as an advocate?
29 years.
And I see from your papers that you've had a varied practice.
I have. I've been fortunate, Deputy Chief Justice.
And you have appeared in pretty much all the courts of this land.
Yes, I have.
Do you have any area of specialty, or is it practice general?
I have a general practice. I have an interest in certain areas, but it's a varied practice. There's some things that I don't do. But other than that, I'd like to consider myself as a general practitioner.
And by all indications, your practice has been quite successful. And we all know just how tough it is for women in our professions.
Yes, it is.
What has been the secret of your success?
That's a difficult question, but my assessment has been, I joined the Pretoria Bar just after the elections. I started off, I finished pupillage in June of 1994. I then came to the Pretoria Bar, and I believe that there was a lot of focus on Pretoria because of its history as being a conservative city. And I believe that that move to try and instruct people of color was very beneficial to me, and that's where I started getting work. I was also fortunate when I did my articles, I built up relationships. And those relationships took me through. Visibility is very important, of course, when you start off at the bar. And that gave me visibility. And then it was good luck, and it was the support of wonderful people. There were attorneys' firms, mainly small firms of attorneys that supported me. But it gave me visibility, and I think there was a little bit of luck there as well.
Yeah. Well.
But one of the things was there was a senior counsel on our floor. I can mention him. It was the former Deputy Chief Justice. And he would encourage, he would walk past my chambers. I'd see him walking past my chambers at 9 o'clock at night, and there'd be that stop at my door and encourage me. And that was, I can say to you that was enormous comfort. So it was a little bit of everything. I'd like to think that there's lots of people that contributed to that.
Well, yeah, it always takes a village to raise a child.
Yes.
You do many things, and among those, you've been a small claims court commissioner and an arbitrator.
Yes, I've been doing some arbitrations. More recently, I've been doing more arbitrations than I had been before.
And why is that, if I may ask?
I beg your pardon?
Why is that, if I may ask? How did that come about? Or you're just getting more work?
No, I think what happens is when one becomes more senior, you find that your practice takes a turn that you don't really expect. And I think that there's also there's a move to giving women more work. The arbitration, that area of practice has been reserved for more senior silks, and I was asked whether I was not interested in becoming a member of AFSA. And I found that once I did that, there were people that requested me to act as an arbitrator. So it's been recent.
All right. And among the many things you do still is you chair the Training and Development Committee of SAULA.
Yes, I do.
Precisely what happens there?
What we do is, it's been a little bit difficult with COVID, but in some way there have been some benefits. So we have training sessions, virtual sessions. For the past 2 years, I think it was 2022, we did the training on a very high level, very specialist areas. And this year, I decided that there was a need to start off with what I called the ABCs of practice management, the ABCs of writing. So we have sessions, and we've now introduced them. We were trying to have weekly sessions. The last month or so, that hasn't been possible. So it's various topics we choose. We choose topics that we believe will be beneficial to young practitioners and more senior practitioners alike.
Okay.
It also gives an opportunity for largely women attend those sessions. We've not excluded men from those sessions, but it also gives them an opportunity to network, and it's also a form of it's also a support structure for especially the young women that attend those sessions.
Right. I was deeply touched and highly impressed by the deluge of letters of support, especially from young women in the profession who have written in, explaining just how much help you've been to them in their struggle as they make their way, they navigate their way in this field.
I was surprised when I read those, and I was touched too. I'm very pleased I've made a little bit of difference in their lives.
Yeah, that is making impact. One of the things that is mentioned is the WhatsApp groups that at first blush one may say, it's just one of those groups. But when you look deeper, it appears that a lot of profound work is done there. What gave you an idea to start that?
Deputy Chief Justice, it's been a long time where I thought about putting in place a structure which will allow women to network for women to get support. It's not, when you sit in when you're a single practitioner, you sit in a small law firm, you find yourself confronted, as I have been at the bar, with the simplest of questions that either you can't grasp because it's presented as being very complex, or they're new issues that you don't know how to deal with. And it's always useful if you can knock on somebody's door. But of course, we can't do that. And I inadvertently created a group the one day. I think it was around about Christmas time, and I wanted to send messages to friends. And I inadvertently created a group. And people got feverishly, I got messages about what is this group. And I then realized I could create a WhatsApp group. That was one of my smarter moments. And then created the group. It was a handful. It started off with friends. And to my surprise, it's grown. And the women, there's only women on the group, I'm afraid. We support each other. And at any time of night or day, if you pose a question on the group, you will find somebody that comes back with the answer. But not only that, it gives us all an opportunity to debate issues. And I find that to be extremely refreshing. I've learned so much on that group. So it's been as beneficial to me as it has been to the younger practitioners.
And you have well over 160 members in that group.
Yes, it might be more, it might be less. There was a time when WhatsApp had a limit on the number of participants. I think it was 256. And at that stage, we couldn't get any more, we couldn't allow any more participants. But with these things, people come and people go, and it could be about 160, yes.
You have acted in the High Court.
Yes, I have.
Okay, I'm not going to ask you any in-depth questions on that aspect. I'll leave it to Judge President Mlambo, who's very meticulous when it comes to these things. All I want to know is how long that your stints have been, and how many judgments you've been able to produce, if any, and if any of them have been reported.
Deputy Chief Justice, I last night counted how many weeks there would be. I haven't looked at what is on the schedule I've now been given, but my estimate was, and it sounds, the JP Mlambo will correct me, but I think it could be in excess of about 45 weeks. I initially started off, I was approached by Judge President Shabalala in Natal, KZN, to act, and I remember doing 4 and 3, 7, about 10 weeks there. So the list that I initially was given indicated 34 weeks. To that must be added the 10 more, and I do believe that there was a term, so I would add 6 weeks. So it was an extended, over the years I've accumulated a number of weeks. I would think it was, I don't believe it was anything less than 40 weeks. Mm-hmm. But the Judge President Mlambo will probably correct me.
Yes. And any written judgments?
Yes. I've prepared 55 written judgments. 55 of those, 3 have been reported. The one I marked reportable, which was, it dealt with the institution of legal proceedings against certain organs of state. And the second judgment that I wrote that was reported, what was reported, when marked unreportable, was a judgment which dealt with Section 13, that had to deal with security for costs by a company after the New Companies Act came into force. And you might recall that Section 13 in the 1973 Act was done away with, and there wasn't a similar provision in the new Act. So that was reported, and recently I've had another case reported. Mm-hmm. So all in all, there's been 3.
All right. You do not have any reserved judgments?
No, I don't. No, I beg your pardon. No, I do. I acted in September. I think I finished acting on the 4th of September, and I have one judgment that needs to be done there.
You mean this past September?
This past September,
okay.
Yes.
All right. The GCB has written an overall complimentary assessment about you, but they do raise the issue of 2 judgments that you delayed, they say.
Yes. DCJ, would you like me to
would you, yeah, what do you have to say on that, if anything?
DCJ, there's 2 things. I did a response in which, to that, I believe that was something that did call for a response. If I may just give a little bit of a background for a moment. These were both third-party matters. With the Road Accident Fund having withdrawn the mandate of its panel attorneys, what happened with the third-party trials is you would have a plaintiff with their reports, and they would seek judgment. The matter will then be decided on the papers, which I found initially very difficult to do, because here's a trial and you're deciding on the expert reports. But my experience was that counsel that presented those cases, probably acting in the best interests of their clients, I would think, would not necessarily draw attention to matters that were unfavorable. And considering that the funds were public funds, I considered it my responsibility to interrogate those. So I would hear an argument for an hour. There'd be 3 or 4 matters on a day. You'll hear the argument. You've looked at the reports very quickly. And when I started writing judgments, I noticed that there were certain things that hadn't been explained. So in the case of the else matter, which is the first one that the GCB refers to, what happened there was the plaintiff had been doing some part-time hairdressing. I remember that specifically. The actuary dealt with that, those extra earnings, but when I went through everything on case lines, there was no evidence to support that. The vouchers for the past medical expenses and the income as well was presented in a very unsatisfactory fashion. I sent an email to the plaintiff's counsel asking him to point me to certain to the various folders on case lines where I could find some of the vouchers. I also asked the basis on which the plaintiff was seeking to be compensated for the part-time activity, the hairdressing. And I waited a long time for those. And I also, it took a long time for me to get a response. It took a long time, some 8 months after the hearing, after I'd requested affidavits concerning the plaintiff's pre-morbid income were uploaded onto case lines. That, unfortunately, didn't come to my attention until the 3rd of December. When these things get uploaded onto case lines, you get a notification, but you get inundated with these, and I don't always look at them. So that slipped me by. It came to my attention in December, and I then started writing the judgment, and I found it most tedious to get through all of those vouchers. So that was really the reason that judgment was delayed. It was unfortunate, and I think where I erred was that I should have immediately contacted the judge president, and I should have said to him, I'm confronted with this, what do I do? What I also found, I found myself trying to present the road accident fund, to try and balance what the defendant's defense was with that of the plaintiff. And I must say that that wasn't a wise thing to have done as well. And I confronted a similar challenge with the second judgment that the GCB refers to. There too, I had communicated with the plaintiff's attorneys, and there it was. Here the problem was the joint minutes were based. So what had happened? A set of experts had met and they'd prepared a joint minute, and they had come to they'd agreed on certain facts. During the course of argument, I was not referred to that joint minute. I was referred to a later report, and I think it was an educational psychologist. And while perusing the files and case lines, I came across this joint minute where there were certain concessions by both the parties' experts. And it then troubled me what the effect of those concessions were, and whether the plaintiff could now try and get behind those by calling a new expert. So I waited. There was then, I believe I had a discussion with the judge president, because there was a letter from the plaintiff's attorney, and I informed the judge president I was sitting with this difficulty that I've not had a response. And the judge president recommended that I prepare the judgment even though I hadn't received a response. So that was the reason for the delayed those two judgments that were delayed.
All right.
I tried to explain that in the judgment as well. I do believe I mentioned it, but I believe that they needed to know why it took so long for those judgments to come out.
All right. There is another objection. Well, I'm not saying the GCB lodged an objection, but this one is an objection from attorney, a colleague at the sidebar, attorney Mohozi.
Yes,
who
I've seen that.
Alleges that you treated him most deplorably and threatened him.
Yes, I read that. When I read that letter, I was taken aback. I couldn't remember the incident. I'm aware of this litigation. It's been going on for some time. Mr. Mohozi acts for an importer. And SARS had detained those goods, and it became quite an acrimonious, the litigation became quite acrimonious. I recall the incident where, my junior had to jog my memory. There was a request for a postponement. I'd been instructed by SARS to seek a postponement for various reasons, and I can't remember them now. And there was a discussion between myself as the lead counsel, my attorney was close by, so was my junior, and the legal advisor from SARS. And you'll note I asked them to give me what their recollection of that incident was. And both my junior, as well as the legal advisor, in their the legal advisor says this did not happen. When you approached him about the postponement, he was very rude. You told him there was no need to behave in that matter, and he walked away. That's as far as I can recall. My junior's response is a similar one. And she talks about the attorney being very hostile from the moment we met him while waiting to introduce ourselves to the judge. The attorney was leading a junior counsel from the Johannesburg bar. And my junior states that the hostility continued even when we walked into court. And she recalls me telling that there was no need for him to be rude. And that sparked an argument. I don't remember you screaming or saying, "I'll bring you down," and making comments about attorneys in the High Court. I have a vague recollection. He's saying to me something about, And I've got to be very cautious because I have a vague recollection. It was something that suggested that my client was being high-handed, that they detained the goods, and they had put his client out of business. I remember saying to him that there was no basis for him to make those allegations. But Deputy Chief Justice, there was not the tirade that the attorney refers to. And I independently asked my junior and the legal advisor and the attorney, and I referred to the conversation I had with the attorney before I wrote the letter, and he's got no recollection at all. There was something that came to mind was, this incident occurred in 2019, February 2019, if my memory serves me correctly. If the complainant, if I may call him so, if he was as aggrieved as he makes out to be, and if my behavior towards him was as atrocious as he makes out to be, his remedy would have been to immediately report my behavior to the Bar Council or to report my behavior to the Legal Practice Council, and he did neither. So I'm afraid to say this, but it's got absolutely no merit. There's no truth to it. The attorney used to be employed by SARS, and I don't know what the circumstances were under which he left, but I've always gotten the impression, and so have my juniors, the legal advisors at SARS, that he's aggrieved by something, and perhaps acting for that client makes him, agitates him. I don't know.
All right, thank you so much for that explanation, Mr. Sim. I'm going to hand over to the rest of the commissioners to put questions to you now.
Yes.
Starting with Judge President Mlambo.
Thank you, Deputy Chief Justice.
Thank you, DCJ, and morning to you, DCJ. I realized that I was remiss. I came running, and I didn't come to greet you, so please forgive me. And morning to President, SCA, other commissioners. Morning, Advocate Hassan.
Good morning, JP.
Thank you. Let's start first with your acting stints. The commissioners have a spreadsheet that we've sent to them that accords with our records, which record in Gauteng a total acting period of about 50 weeks. I think both Gauteng and KZN.
That sounds about right, Judge President.
Just before I go deep into these acting stints, you came to this commission in, was it 2013?
Yes, I believe it was, yes, 10 years ago.
2013, and this commission said you're not ready.
Yes, that's my recollection.
And you accepted that, am I correct?
Yes, I did.
You didn't sulk, you continued acting.
Yes, I did. I believe that was my duty.
Yes.
To continue to do so.
Since then to now, you've done a lot more work.
Yes, I have.
Do you believe you've grown? You're now ready?
I do believe I have, Judge President. I've written a lot more judgments. I have had the benefit, and for that I must thank you and the Deputy Judge President for giving me the type of work that's allowed me to develop my writing skills, to develop my analysis skills, and I was quite surprised when I took an inventory of the number of judgments I'd written, and I must say I was surprised myself that I had written about 55 judgments.
Yeah, and most of your contribution to the division has been in the opposed motion, where I believe you've done, I think, 12 weeks in total,
yes,
over the years.
Yes, I think that's about correct.
That's a difficult court, am I correct? And that's a court where judges pick up reserved judgments.
Yes, yes, Judge President, that's what happens. Unfortunately, some of the matters, even there's a varied number of cases where I could give extempore judgments, I would, but I found that I had to reserve
Yeah.
very often.
And the norm, when you get onto that role, is if we don't have pro bono assistance from the bar and the senior attorney ranks, your allocation is something of 14 opposed motions for that week.
Yes, that's about correct.
And you
yes.
have no writing time. And when you finish that week, you go on to another work area.
Yes.
Okay. Now, let me come to those two reserve judgments. I know those were trial judgments.
Yes.
Usually, my experience as JP is that acting judges, and judges for that matter, who struggle to finalize judgments quickly is because they are grappling with the issues, and it's mostly a complex matter, like a special motion or something that cropped up in the opposed motions. These were trial matters.
Yes.
The delay was caused not because you were struggling to write the judgment, but because you were not having access to the right material in the case lines folder to write the judgment.
Yes, that's correct. And because certain material information hadn't been provided to me.
Yeah.
I was, at some stage, I was told, but why don't you just grant default judgment? But that didn't sit very easy with me. We were here dealing with a defendant that refused to participate.
Yes.
There were issues of public funds. So I did take a lot of trouble trying to find it. And yes, there were things on case lines I couldn't locate. And it was sad, and it was a disappointment how particularly those two matters were presented to me.
Well, you go on to an area I wanted to cover about those judgments, because you're correct. There is a view from some ranks that say it's a default judgment. It's like a penalty with no goalkeeper. Just allow them to score it. Why? What's your business in checking whether everything is in order? I noticed that one of those claims was 6 million rand, isn't it?
Yes, I think it was.
Yeah. Now, what's your philosophy about it? Comes unopposed to you, they say they want this, therefore just rubber stamp it.
I have a difficulty doing that, Judge President.
Yes.
I do have a difficulty, especially when the case is presented to you on the expert reports. And the whole idea about compensation being claimed is for the court to assess the reasonableness of that compensation. And I'm not always satisfied that the compensation which is being claimed is reasonable. I've done third-party work myself, and it is not unusual for higher compensation to be claimed, and then for less to be awarded. That's claim as much as you can. So I'm not comfortable making those awards. What I also realized is that the actuarial calculations, the premise that it's based on is not necessarily what the experts agreed upon. And so I started interrogating all of that. So I believe that...
Well, I think that I want you to continue. There's a tussle now between us as courts about whether we can do that regarding settlement agreements. That is, claims that have been settled, and so let's leave it. But
yes,
this was a default judgment matter where they were saying to you, we want this, and you said no.
Yes.
I need to be satisfied as judge because the judgment will have my name.
Yes, that is correct, JP.
In terms of reserve judgments, you've provided a list of judgments that you've penned, as you say. Some of them were penned when you were in the KZN division. Most of them were penned when you were in Gauteng. And just going through them all, I noted some, I think of 2 that were 7 months late, probably 4 that were 5 months late, but in the norm, all the others were in that range. That is less than 5 months, 3 months, 4 months. Can you explain what was the reason for that?
JP, I've thought about that.
Yes.
And I think I think what I did is I miscalculated how much time I needed to allow. Firstly, to prepare beforehand, because these were opposed motions. What tends to happen is you don't allow yourself enough time to prepare before you commence your stint.
Yeah.
You then hear the matters, and I've never left any time after I've finished an acting stint and I plunge back into practice. And what I then found is that with the demands of practice, you can't always get to writing those judgments quickly enough. And I believe that it was, if I had prepared, if I had paced myself and allowed myself a week or two after I had completed my stint, I would then probably have been able to write the judgments a lot quicker. The other thing was you'd start writing a judgment and then you'd get interrupted. And for me, the only way to do it is to literally sit at a table, start to finish. And I was not able to do that.
I see. But, I mean, as you sit here today, should you be appointed, you won't have the challenge of a busy practice next to you.
Yes.
You don't think that problem will continue?
No, JP, no, I don't believe it would, because it's the demands of practice, and when you get back in, that was the reason for the delay. If I'm to be appointed, I would also have a lot more time to prepare matters beforehand, and I believe thorough preparation makes it a lot easier to get the judgment out.
Yes.
So,
but your firm view is that that's not an indication that you can't do the work.
no, absolutely not. Judge President, if I may mention,
Yes.
if you, and I've only attached, I think 5 or 6 of the judgments that I've written, but the judgments that I have written are in this file and they're double-sided.
Yes.
And my judgments are generally not short judgments. I believe that the parties are entitled to have the reasoning. So I do take time. To put that together.
Yes.
But I don't believe when I'm able to sit down and work and not have demands of practice,
yes,
that I will certainly be able to achieve writing judgments within the requisite time. You'll recall there were times that I think we communicated and I indicated to you that I was having some challenges.
Yes.
I tried to keep you abreast of matters as much as I could.
Thank you. My last 2 questions is, I think you've confirmed to this commission that since 2013 you've grown. You've
Yes, I
written a
have.
lot more judgments. You're now more ready than
Yes,
ever.
I certainly am.
And you're a silk. You've led teams. Am I correct?
Yes, I have.
You're one of the few silk women that we've seen in our courts leading legal
Yes.
teams.
Yes, I have.
And you believe all that has equipped you to deal with the rigors of the Gauteng work?
Yes, absolutely. And those acting stints that I've had, I would like to think with a preschool for me, because I learned how to deal with certain matters, and all in all, I didn't have difficulty when I was hearing matters. I could manage a court, and I'd like to think that I managed the court relatively well.
Yes.
I could finish unopposed motions within a quick space of time. So I was able to do that. So that's been a very good training ground for me. The work experience that I've had has also equipped me to deal with matters slightly differently than I would have in 2013.
Yes. Okay. Thank you, DCJ. I've got no further questions.
Thank you, Judge President.
Thank you, JP. Premier Lesufi, are you among us? I'm sorry, I forgot to check on the colleagues on the virtual platform earlier, but I was assured that they have joined in.
It's usually...
Yes, I'm indeed here.
Oh, I see.
There he is. All right. Do you have any questions for this candidate?
Thank you so much, Chief Justice, the Federal Commissioner. Good morning, Advocate Kasim.
Good morning. Is it on screen? I
No,
can't-
he's patched in virtually. So
Oh, I see, yes. Thank you.
Just two questions, Deputy Chief Justice, if you don't mind. The first one, I just want to ask Advocate Kasim, when you are having that stint in the small claims court,
Yes.
and if someone has to ask you to advise authorities on the functionality and the work of the small claims court, what would you advise so that it can be improved?
Premier, I'm afraid I'm having trouble hearing. The audio is not coming. For me, I'm having trouble hearing it.
Yeah, so am I. It's not just you.
Oh, is it just not me?
But were you able to get the gist of the question?
There was something about the small claims court.
Would you mind, your line is not particularly clear, Premier. We're struggling to hear you. I don't know what you can do, but can you repeat the question and
Could I assist DCJ, because I think I heard the question.
oh,
I think the question was, you've done work in the small claims court. What would you share with the commission as being the challenges you've observed, and what can be done to preserve that system of access to justice?
There's a few things. I think I haven't been in the small claims court now for some time. I think that the help desk, there used to be a help desk there before. And now JP, I'm looking at you because you posed the question. I'm going to try and look at the screen.
Repeating the previous
Yes,
question.
yes, so I don't mean to be disrespectful to the Premier. I think there should be more information that's circulated about the small claims court, what can be done, and how easy it is to access a small claims court. I also think there needs to be, there used to be a help desk, I'm not sure if there still is, but I think litigants, or whether in the small claims court or any other court, tend to get intimidated, and maybe there should be a more of a user-friendly kind of atmosphere. I think it's a very good court. I think it allows people to resolve disputes quickly and cheaply, but also it gives access to people that would otherwise not refer their disputes to court. I know that, I'm not sure what the current jurisdiction is, monetary jurisdiction, but that jurisdiction is high enough to be important to people to pursue their claims there. Thank you, Premier.
Thank you so much, Advocate. I hope I sound better, Deputy Chief Justice.
You sound clearer now.
I've changed gadgets. Apologies about that. Deputy Chief Justice, if you don't mind, I just want to go back to the objection by the Mukhumutsi attorneys.
Go ahead.
Especially when the Advocate Hassim indicates that the basis of the objection should not be considered because it was not tabled with other institutions before, meaning that even if there are processes like this one where people are invited to raise objections, Advocate Hassim feels that is not the correct platform to raise this kind of an objection. And I've gone through the objections. Somebody that feels mistreated, disrespected, and Advocate Hassim implies that her memory didn't carry her well to recall, but has relied on an information of those that were working with her at that time. On that basis, I really feel that should have demonstrated willingness to either engage a person that is objecting or at least apologize, because the victims will always remember the pain. The perpetrator will not. And I don't find the explanation to reject this objection convincing. Am I wrong, Advocate Tassin?
Premier, perhaps I wasn't clear. I'm not saying that because he didn't pursue other remedies, that it is not appropriate for him to raise the question with this body. Of course he's entitled to. There's a procedure that's in place, and the public must be encouraged to object to the suitability of a candidate. I think that's important. There's transparency about that. What I meant to say, and perhaps if I wasn't clear, if I may clarify, I would have expected, if there was a real grievance, that would have been addressed 4 years ago, because I believe the incident was in 2019, this is 2023, this is 4 years later. I have seen this attorney on several occasions. We've litigated this matter at least on 3 separate occasions. I've seen him in court. He's never approached me. Had he approached me, I would certainly have discussed the matter with him, and if he felt aggrieved, and I would have apologized unreservedly. There is no question, if somebody feels aggrieved and you're responsible for that, one should apologize. One is never too big to apologize, and I've got no reservations about apologizing. I don't recall the incident. It is the words that have been mentioned there are not words that I use. I don't remember ever criticizing an attorney for appearing in the High Court. In fact, I encourage them to do so. I encourage my attorneys to appear in the High Court. I've encouraged attorneys to join the bar, because they were not comfortable appearing otherwise. So I would never discourage an attorney from appearing in the High Court. I do believe it gives great growth to the individual to do so. The words that are mentioned, that I was going to bring him down, it's not something that's characteristic of me. There was no reason for me to be upset with my colleague. I've not had an incident in the past in my professional life of 30 years. To that, one should add my 2 years of articles and my 1 year of practice. So that's almost a little under 33 years, 32 years of practice. I've never had a complaint of this sort, and I've never responded. That's not generally my manner of doing things, that kind of aggression. I had no reason to do so. The attorney was representing the interests of his client. There was a request for a postponement. The judge was ready to hear the matter, and nothing I would have said to the attorney would have changed his instructions. And we were in court. We were ready to argue the matter. I wish that Mr. Mokgotsi approached me. What I can add, and I was very reluctant to do so, but now that the question has been put to me, I believe that to be fair to everyone, I should say that there have been letters that have been written by Mr. Mokgotsi, which I've seen, which have been aggressive, very hostile, and they've, I don't want to say they're defamatory, but they're not the type of letters that one would expect coming from an attorney. The papers which he drafts, and if I recall correctly, he drafts the papers, he would, the language is aggressive. It's not the type of language that that I certainly am accustomed to in court papers. Had I known that this was something that would need to be explored further, I would have ensured that I had some of those affidavits here so I could read them out to you to understand the personality we're dealing with. I have been told by various sources that the attorney was aggrieved when he left SARS, and anyone who appears for SARS is the target of his ire.
I'm not entirely sure. I'm sorry, Ms. Hasim. I'm not entirely sure that it's proper to to go as far as you do in the latter part of your explanation.
Yes, thank you,
Yeah, let's-
Deputy
yeah.
Chief Justice. Thank you. Thank you, Premier.
Any further
Thanks so
questions?
much.
Oh, any further questions for the candidate Premier?
No, fine. Thank you so much.
Thank
Justice.
you. Thank you very much. President Molemela?
Thank you.
Boys, should I go ahead? Okay. Thank you, DCJ. Good morning, Advocate Hassem. How are you?
Good morning. I'm very well, thank you.
All right. I noted that your first acting stint was 18 years ago, 2005.
I think it was 2004, but I stand to be corrected. Yes, it was a long, long time ago.
Yes.
I think it was at the bar for 10 years at the time,
Yes.
perhaps 11.
Yes, and since about 2013, you've been having an acting stint almost every year,
Yes,
and you have been exposed to a wide variety of fields of law.
yes, I have.
I was quite encouraged when you, in response to the JP, you mentioned, a very cautious approach that you follow when you are dealing with default judgments.
Yes, I do.
You have obviously, in the various acting stints that you have had, dealt with ex parte applications.
Yes, I recall now in my recent stint, there was one. I can't remember what the facts were. So yes, I've actually, in the past, I've brought ex parte applications as well. But have I heard them? I think I have a recollection of only one.
Yes, it is. Under what circumstances is an ex parte application relief granted?
If the giving of notice will defeat the object of the application, I believe that is the test.
Yes. Can you think of an example?
I suppose a good example would be where, let's assume you have a suspect that's about to flee the country that you can't get hold of, or there's access to money. And usually that's the ones that tend to come ex parte.
Yes.
With his money in the bank account, if you were to give notice to the respondent, by the time the order is granted, the likelihood is quite strong that the money won't be in the bank account. So that's the typical example, or that's a very quick example I can think of.
Yes, so in circumstances where you were inclined or where you would feel inclined to grant an ex parte relief, would you grant a final order?
No, I certainly would not.
What kind of
I
order
would
would you
do. I
grant?
would do several things. Firstly, I will establish whether any notice, even if it's a telephonic notice, to say to the person, "I'm in court. I might issue I might consider issuing an order, an interim order immediately." Allow the party to come back to court on the same day, depending. But I would generally, I would definitely not issue a final order. I would issue an interim order, usually in the form of a rule nisi.
Thank you, Ms. Hassem. Thank you, DCJ.
Thank you, President.
Commissioner Marumahai?
Thank you very much, DCJ. Good morning, Advocate Hassem.
Good morning.
I just want to ask you a procedurally sort of inclined question. Assuming that you are sitting on a matter in the High Court and the parties are just preparing their affidavits and so forth, and the full set of affidavits have already been filed, and you find that one or both parties file further affidavits.
Yes.
Perhaps maybe it might be a further affidavit, or it might be a supplementary affidavit of one of the affidavits that are already that have already been filed.
Yes.
One, is that allowed? And if it is, what is the? I'm not sure if I can say a test that one should follow in order to get those affidavits to be admitted, because it seems like in practice. There are legal practitioners who believe that they can just slip in those affidavits in. What is the correct procedure to follow when one has to deal with those kind of affidavits? Thank you.
So the first thing that one would determine is whether the affidavit, for example, is an affidavit supplementing a founding affidavit, because the case, of course, has to be made out in the founding affidavit. If that is the case, I would think that you would have to bring an application asking the court for leave to file that affidavit. And in that application for leave, one of the things you'll have to address is why the need for the supplementary affidavit arose, and why it wasn't that evidence was not put in, for example, in the founding affidavit, or if we're dealing with an answering affidavit, why it was not introduced in that affidavit from the outset. The other situation in which one would come across the need to file a supplementary affidavit is where there's new matter introduced, for example, in a replying affidavit. You will then find that the respondent would like to have an opportunity to deal with the new matter. Generally, one would have to seek the leave of the court and make out a case why it is that further evidence should be received.
Thank you very much. DCJ, with your leave, can I ask a substantive question? Or should I? I'm not sure what is the agreement, whether one question or...
How have you been doing it in the last 3 days?
It has varied. On the first day, it was 2 questions. Yesterday, it was like 1 question.
Well, the first 2 days were senior courts. And I thought the agreement was 1 for the...
No, I will leave it there.
And
that's fine.
you know that, Prof. Okay.
Thanks, DCJ. Morning, Advocate Hassim.
Good morning.
Let me also join and commend you for what you have done since the last time you were here. 10 years ago, in 2013, when we were here, you clarified us about the plight of women.
Yes.
If I can remind you what you told us, that women start off at the bar with some work, usually unopposed divorces, and if they are lucky enough, they move on to opposed divorces. Their white male counterparts seem to progress to a level where they get more complex work. As women, you reach a certain level, then stagnate, like you hit at last ceiling.
Yes.
Assist us to understand 10 years later, what's the situation like?
Commissioner, I would like to have told you that great progress has been made in the last 10 years, but I'm afraid I can't say that. There has been some progress. What you do find is junior counsel are brought into, young women are brought into far more complex matters where they're being led. But the progress has been very slow. You would find in the courts now, you would have junior counsel being led by a senior counsel in specialist type of matters, which didn't occur much 10 years ago. But I'm afraid that unless you are fortunate enough to get that kind of exposure, there are still great limitations that women not only advocates, women lawyers face. I hope in another 10 years I can tell you differently.
Thanks, Advocate Hassim. Thank you, DCJ.
Thank you.
Commissioner Matolo Dlepo.
Thank you, Deputy CJ. Good morning, Advocate Hassim.
Good morning.
Mine is not a question, it's just I see that you don't like blowing your own trumpet.
No, I don't.
I'm just highlighting to the Commission how much work you have done for female attorneys. And you are one of the few SCs who really go out there and make sure that female attorneys get recognized. So I want to applaud you for that.
Thank you very much. I appreciate it.
Commissioner Lukias.
Thank you, TCJ. Firstly, I must say the objection that relate to that attorney and the encounters, I think it was considered by the objections committee and it was dismissed for lack of merit, as I understand. The Premier was not part of that. And coming to my question is, the Constitution instruct courts to apply customary law in matters. I mean, it recognizes customary law and instruct courts to apply principles of customary law and develop it on matters that concerns issues of customary law. What are the safeguards that you believe the court should adhere to in applying principles of custom? Can the court apply? Can the court infuse common law principles in a customary law dispute?
I'm not sure that perhaps they can. For me, I would think whether that can be done or not is dependent on whether it falls within the bounds of the Constitution. If it falls within the bounds of the Constitution and what is intended to be imported one way or another, if it doesn't fall within the bounds of the Constitution, then I would believe that that's not permissible.
Commissioner Bernard?
Thank you, DCJ. I had a follow-up on the question of the Premier. May I first do that before I ask my question? I think we did say follow-ups are in order.
Sorry?
DCJ, I asked whether I may first do a follow-up on the question of the Premier before I ask my question.
All right.
Thank you. Advocate, good morning.
Good morning.
You mentioned something about an apology, but then the discussion went in another direction. So I just thought if you could just clarify whether you'd like to offer, even if it is qualified, some sort of an apology to the practitioner involved or not. It's just to give you that opportunity, because I think you were going in that direction and then went in a different direction. Would you like to offer an apology to that practitioner?
Commissioner
Even if
Barnes.
qualified.
Commissioner Bernard, I'm sorry, I missed part of. I just got distracted. I missed part of your comment or question. Are you asking the candidate to apologize for the complaint that was lodged with us?
No, Chief. I don't know the DCJ. What I'm asking you, she did, in an answer to the Premier, it did sound as though she was touching on going into an apology, and they didn't. So I was just giving an opportunity if she wants to offer some sort of apology or.
No, Deputy Chief Justice, I must interject on behalf of this candidate. I'm not here, counsel. But I think it's responsible for us as the Commission. You have no reason to apologize. We asked you an opportunity to give your representations. You've given your representations. We looked thoroughly at the merits of this complaint. This is a usual altercation that happens outside of court. And that's why we rejected it on the merits. So to now say to a candidate, no, please apologize, is putting the candidate in an extremely awkward position. Because she wants to get the job. She's now forced to apologize, but it's a false apology. So that is why I think that we should stick to what we decided at the Objections Committee, which was accepted before we commenced these proceedings. Thank you, TCJ.
Thank you for the intervention, Commissioner Ngugaitobi. That is precisely what I would have said, and I'll take it further. You have absolutely no reason to apologize, Ms. Hasem.
Thank you, Deputy Chief
But
Justice.
I think DCG, because Advocate Ngugaitobi is on the complaints committee, let me say, we received the report on that complaint and we are satisfied that there is no reason for an apology.
Indeed. Thank you, Commissioner Lucas.
Thank you very much.
Does that take care of your rejoinder, Commissioner Bernard?
DCJ, I'll accept the ruling in that regard. Can I ask a question?
Yes.
Thank you, DCJ. Advocate, if you could instantly change one thing about your judicial temperament, improve something, what would it be?
I believe that I have the right judicial temperament. Of course, if there was somebody that would point out to me any shortcomings I have, I certainly would try and improve that. You might have noted from the, beg your pardon, the comment from the GCB that there were no complaints about my temperament in court. There were no complaints, and if I remember correctly, there might have been a statement that I receive practitioners well in my court.
Thank you, DCJ. Thank you, Advocate.
Thank you, Commissioner.
Commissioner Minister.
Yeah, thank you, DCJ, and good morning, Judge. Advocate.
Good morning, Mr. Minister.
Yes, my question relates to the SAB, is it South African Bureau's case, where you found on behalf of SAB for the defendant to put security on a matter. When the common law principle is that nobody but a peregrinus or a foreigner could be called upon under any circumstances to give security for cost.
Yes.
It could be the circumstances or the merits of the matter in this one might have dictated how you found. But my question relates to Section 34 of the Constitution. Don't you think that if we have a common law that develops to the extent that an incaller or a resident of the country must put security before when they litigate against some of the big corporates with big pockets, it might frustrate access to justice for some of the poor litigants in the country?
Yes, thank you, Mr. Minister, for that question. This matter concerned specifically the furnishing of security by a company. I know of, unless in the case of vexatious proceedings, I know of no case where a incaller has been required to provide security. And I certainly, unless there are very exceptional circumstances, would not be inclined to have a natural person required to give security, because you're quite correct, that will close the doors of the court to such a person. In the case of companies, I believe the principle is somewhat different.
Thank you.
Follow up, DCJ. Thank you. On the question that the minister has just asked, and I think your answer is quite helpful. There is a particular rule in the Uniform Rules of Court where when a person applies to appeal and leave to appeal has been granted, in order for the appeal to be heard, and I'm talking about natural persons now, in order for the appeal to be heard, you have to furnish security. And sometimes, if you cannot agree with the parties to the amount of security that needs to be paid, then the registrar must come in. And there's always a contention under those circumstances. What is your general view in respect of that particular rule?
The security is only insofar as the costs are concerned, as in the case of the company, the case. I haven't studied that rule in any great detail recently, but it might very well be that there is room to to approach a court to dispense with the furnishing of security. And I think that would be where the remedy lies. But I must be forthright, I've not looked at that rule for a very long time.
No, you are correct, actually.
Yes.
Thank you very much, DCJ.
Commissioner Shabangu Mdawe.
Thank you, DCJ. DCJ, let me start by declaring that I know Advocate Hasim from Saula as a member, as well as the chairperson of Training and Development Committee. Good morning, Advocate Hasim.
Good morning.
Mine is to commend you on what you have done for, or you continue doing, for young women legal practitioners. What I want to find out from you, if you are appointed as a judge, will you continue assisting those young women and empower them?
Commissioner, I'd like to say yes, because I certainly would want to continue doing it. I do believe that there might be certain restrictions. Of course, before I undertake any such activities, I would like to confer with the Judge President whether it's permissible. But I certainly would like to continue with the training and development program. Insofar as the WhatsApp groups are concerned, my concern with those groups is that certain questions are posed. Of course, if you're a judge on that group, you might become privy inadvertently to confidential information, or you could become privy to certain difficulties in the case. It might then be that that matter comes before you. I believe it's quite possible that you could be compromised. So insofar as those WhatsApp groups are concerned, I would be concerned if I were to remain on them, as much as it will really pain me to leave those groups. But I do believe there are lots of people, and I'll be leaving those groups in very capable hands. But apart from that, I would welcome an opportunity to continue with the training and support, not only training, but support. Women need women lawyers. We've seen it in Saula and in other organizations, need more than, they need networking, they need support in practice, and they also need, for want of a better word, they need a shoulder to lean on sometimes.
Thank you, Advocate. Thank you, DCJ.
Thank you.
Well, I know that a number of judges in Judge President Mlambo's division, including him, are very active in the mentoring of young, aspiring, and particularly women lawyers. So if you are appointed, you'd be in very good company.
I would appreciate the opportunity to continue doing so.
Good morning, Ms. Hasim.
Good morning, Commissioner Kane.
I must just declare publicly that we've known each other for a very long time. We did pupillage at the same time, although at different bars, and have, since our very junior days, been involved in the bar structures.
Yes, we have.
Now, as you'll be aware, there are 4 vacancies and there are a number of applicants. And one of the aspects which I'd like you to address, because it may distinguish between the applicants, is the extent of your involvement in bar affairs and its structures since your very junior days. There's been emphasis on the great contribution you've made towards junior women, but it's been a broader involvement with that, and I think that it would perhaps do your application an injustice if that were not publicly expanded upon.
I have participated in various structures, you're quite correct. I became involved in the National Bar Examination Board, initially as an examiner and then later as a chief examiner. I joined the board at a time where, if I remember correctly, it was dominated. I'm being too gentle when I say it was dominated. It was a white male board. When I became an examiner, I excuse me, I encouraged black colleagues and women to join the board, and when there was a vacancy, I'd approached colleagues and I'd encouraged them to make themselves available. That's one of those structures that I can immediately think about, that I participated in.
Thank you very much, Deputy Chief Justice, and good morning, Advocate Hassan.
Good morning, JP.
DCJ, my question was going to be around the complaint, but I'm satisfied that with the explanation by the advocate and the report by the Complaints Committee, and also to say it is not uncommon for us to receive as a JSC complaints just a few days or a week or so before somebody applies for a position that we have to consider.
Yes.
So I just thought I'll make that statement, but also to indicate, Advocate Hassan, on a lighter note, do not discount your KwaZulu-Natal heritage, because your naval code is buried there. And we know about the naval code, Deputy Chief Justice. Thank you very much.
Now, I mentioned, not at all, it was very strange. My parents were staying in Pietermaritzburg, and I was, I think, 2 months old, and we left. And for many years, I was very aggrieved that I didn't know my birthplace. And I recall at some stage where I demanded that my father takes me to Pietermaritzburg so I could see where I was born. And then there's little other anecdotes that bring on very fond memories.
Well, thank you.
Thank you, Deputy Chief Justice. Good morning, Advocate Hassan.
Good morning.
Just back to those reserve judgment comments that were made by the GHCV. I noticed that all three of them involved road accident fund, and the questionnaire approach that you took. You alluded to the fact that that was important because you are dealing with the public money.
Yes.
Yes. Now, the question that I want to pose is, given changes that is taking place in the road accident fund, particularly as it involves many, panel of attorneys.
Yes.
And the fact that, on the other hand, there has been issues raised around the need to protect public money.
Yes.
Now, the question that I want to pose is as to whether that questionnaire approach did it not take place at the expense of the victims. I'm mindful of the fact that there's been many point of disputes in the last 3 years around changes that are taking place in the road accident fund, the fight with the Auditor General, the dissatisfaction by BLA, I suspect also by the Legal Practice Council. So the question that I want to pose, while it is important that all those factors must be taken into account, particularly the quest to turn around the situation, because at some point road accident fund was in the red. But your questionnaire approach, the question that I want to ask, did it not happen at the expense of the victims of the road accident fund, or the beneficiaries of the intended beneficiaries of the road accident fund? Thank you.
Yes, thank you, Commissioner, for that question. It's always a difficult exercise when you've got to balance these rights. But you'll recall that this was not a case that I delayed just because I didn't get to write the judgment. There were, I believe in that case, what I tried to do was to establish whether the plaintiff was in fact entitled to the compensation. My concern was that that case hadn't been proved. If I had simply ignored that, that would have been prejudicial to the plaintiff as well. If that claim of hers, for example, the one claim for the part-time job as a hairdresser, if I had simply rejected it, that would have been a grave injustice if in fact there was evidence that could support it. I saw that as a shortcoming in the presentation of the case for the plaintiff. Of course, I didn't know that that evidence was not there. In both the cases, there was degree of shortcoming on the part of the plaintiffs, legal representatives, and I had requested them to provide the information, and the delay was largely caused by the failure to respond to my requests. But you're quite correct, those types of cases, they need to be dealt with expeditiously because there are injured people that need to be compensated, and some of those injuries we all know are horrific.
Thank you, Advocate. Thank you, Deputy Chief Justice.
Thank you.
Commissioner Lucas.
Thank you very much, Deputy Chief Justice. Good morning again, Judge Hasim.
Yes, thank you.
No, I went through your papers and saw that you have been nominated very early for Eisenhower Fellow, as well as the Philip Reed Fellowship. My question is, how did that programs contribute to your own development?
No,
and how did it also contribute to you being someone that take empowerment of others very seriously?
Sorry, Commissioner.
That is the question.
Yes, thank you. If I may correct you, I was not part of any of these programs you refer to, the fellowships.
No, it's fine.
Thank you so much.
Are there any questions for the candidate from the virtual platform? No.
Nothing, Chief Justice.
All right. Thank you. Well, it does appear that we've reached the end of your interview, Ms. Hasim. I just want to say this. It's not often that senior practitioners and silks, especially the women, few as they are, make themselves available for judicial appointment, which is such a pity. So thank you for applying and good luck.
Thank you, Deputy Chief Justice.
You're
Thank you,
excused.
Commissioners. Thank you for the opportunity.
I'm waiting for you to finish your business, sir. Thank you. Good morning, Ms. Mohammed.
Good morning, DCJ. How are you doing this morning?
I'm fine, thank you. How are you?
Very
is
well,
the,
thank
is the question.
Very well, thanks. I've had a bit of a preview, so it's a little more welcoming.
Good. Glad to hear that.
Thank you.
You hold a number of academic qualifications.
I do.
You have a BA, an LLB, an LLM in corporate law, and a long one of diplomas and certificates.
I do, DCJ.
Mm-hmm. I was just struck by one of those certificates which you obtained from the South African Detective Academy. I didn't know that such an institution exists.
Well, that tells you how old I am.
Yes. What is your employment history? Where did you start? Can you just take us through your employment record briefly?
DCJ, I have spent most of all my life within the world of law, whether it was at a fancy Santon office or a pro bono office. I have done a cross-section. I started off my first bit of work with the Legal Resources Center in Durban, which provided a great deal of opportunities to identify what would have been challenges which unfortunately still persist. I also taught law on a part-time basis very early in my career. Subsequent to that, I've served as an article clerk for 2 years and was admitted to the sidebar. Thereafter, I joined the Office of the Public Protector, which was the first public protector against Judge Bakwa. Following that, I had an opportunity to join the Scorpions unit of the NDPP. Also provided valuable opportunities in forensic work. Thereafter, I was offered to start up what would be a public interest litigation unit for the Legal Aid Board, where I spent a short time. I also forgot to tell you that I actually was a practicing attorney for 3 years in Durban before I joined the Office of the Public Protector. Once I had a sense of everyone else practicing the law, I decided I would like to do that myself, and thereafter joined the bar in 2007, where I have, been working. I think that sort of covers most of
Yes, it does. You have had occasion to act as a judge in Johannesburg and Pretoria.
That's correct.
In sum, how long have you acted as a judge?
I should think it's an average of, a maximum of 41 weeks. I've done 41 weeks to date.
And you sat in both the civil and criminal courts?
I've had most of my exposure within the civil courts. I have, though, written a criminal judgment on appeal.
And I see you did get a chance to produce written judgments.
Oh, yes. I think we are at a total of 59 judgments to date.
Any of them reported?
I've had the courage to report one fairly recently, DCJ, and it's not on your list because it's been a very recent judgment.
What was that about?
Essentially, it was a very interesting matter where we actually do have the law, but we also have to look at the implementation of the law. And this was essentially a public auction in which the sheriff decided to cancel the first sale and accept an offer from a second buyer, a resold property. And the sheriff's reason was that he did not believe the first buyer was actually reliable in terms of having to pay the purchase price. He took too long to pay, and the length of time in calculation was literally 42 minutes. The second buyer followed a similar process in the second sale, and his bid was accepted some 2 hours after he paid for the property. And I thought that that was a serious inconsistency. I also thought it was necessary to report this because there's very limited case law on the concept of when the hammer falls and whether in fact payment is on the day or payment that appears in the sheriff's account should be on the next day. And my finding was that if the conditions of sale, which is a document that is prepared by both the creditor and the sheriff, tells a buyer that he can purchase and his monies will be accepted by EFT, then I think the business sense of all of this is that the monies would then at least be expected to appear on the next day. Unless, of course, the conditions of sale set out details of the banking details of the sheriff, then a buyer is now aware that these are the banking details, and I must make sure that the monies must be paid as soon as the hammer goes down. And he would then obviously make an arrangement with the bank to ensure that the monies are paid directly. But if there is no such detail in the conditions of sale, which is what happened in this case, then what would be normal banking practice is acceptance by EFT. It's fair to expect that the monies would be paid, or rather reflect in the sheriff's bank account on the next day. So I found one judgment in which the judge referred to the business efficacy test and thought that that would be the sensible way to go, where it would be a tacit term of the contract that payment would be accepted on the next day if payment is accepted by way of EFT. That's the crux of the judgment.
All right. You have listed 4 reserved judgments.
Yes, they've all been delivered.
Oh, that's good to hear.
I do though have one reserved judgment. The matter was finalized some 2.5 weeks ago, so I'm trying to work with that. It's been 28 days of evidence, so I have a lot of work ahead of me.
One of the professional bodies who have commented on your candidature expressed the view that you could probably benefit from more acting stints to gain more experience. With 59 judgments under your belt and 41 weeks of acting experience, do you have any comment on that? What's your view?
DCJ, I paid attention to the comments. I also looked at the reason for the decision taken by that body, and it doesn't seem to be correct. The body actually states that I need the training in order to learn what would be first principles on costs. And they relied on one of the 3 judgments that I submitted as part of my application. If you look at judgment number 2 and 3, there is an objective demonstration to you and this panel that I actually do have an understanding of the first principles.
But what do you say about the complaint that in this particular one, Kaslasi, you did not
I didn't grant costs to the applicant, although he did get whatever he had come for in terms of relief. However, if you look at the judgment and the relief granted, it's very conditional on the fact that he supported his removing the children from the country for a few weeks by depositing with his former wife a sum of money in trust, so that if she has to go looking for her children, she would have that backup. And that is not, in my view, an unrealistic fear, particularly in that the facts of this judgment, this matter, demonstrate as well that the applicant himself understood her state of mind. He tendered 100,000 rand. So he understood that she might actually have harbored fears that might have a lot of truth to it. So I looked at the overall facts and decided that I actually had to try and incorporate all parties, all role players, but more importantly, the matter was on my role on an urgent basis. The matter was not urgent. It was self-created urgency. It could have been brought on the normal role, or very, very much, at least much earlier than less than 24 hours notice. If you look at that judgment, and very much in the early part of the judgment, I do set up the urgency with which the matter was brought on less than 24 hours notice, the depth of papers that both the court and the opposition had to actually traverse in a very limited time. And I didn't think it was necessary. And I heard the matter for one reason only, and I think that also appears in my judgment, is that as upper guardian of the minor children, I was enjoined to hear the matter and to ensure that I have actually helped the minor children enforce their rights, whether it be rights to movement, to cultural participation in their lives, etc. So I don't believe that I don't know the first principles. I believe I do. And it's very interesting, DCJ, that around the time that I delivered this judgment, this was the family court, and matters were urgent. I had another matter soon after, in which I demonstrated an understanding of the first rules. And at the end of the day, as far as costs are concerned, the primary rule is that a judge has the discretion. Unless there's some sort of capriciousness demonstrated or bias on the part of the judge, in my view, it was a very fair judgment.
Right. You have experience also as an arbitrator and mediator with AFSA. Have you been able to apply your skills in this regard?
I have. I must thank all involved for the opportunities that I've had as far as alternative dispute resolution mechanisms are concerned. They are so critical. My view on mediation is that it really must form part of our law. There is a huge trust deficit in our lives, in our country, and globally as well. Mediation is an opportunity to get the parties themselves to hear one another and to effectively participate in their dispute resolution. So I've done a few mediations, I must say, and I've also had an opportunity to develop other young counsels. I've done a fair amount of shadow mediators, involved them and included them in my meetings. And as far as my position as an arbitrator, I've sat on one matter, very dependent on briefing patterns, of course.
Mm-hmm. And you say in your papers that you've worked extensively on a pro bono basis with law clinics since 2018.
Yes, I have. I'm very committed to access to justice. Apart from my physically assisting pro bono officers, I try to remember the general public in my judgment writing. in the way in which I receive people in my court, in the way I get a message across to unrepresented and unsophisticated, I use that with caution, parties. Access to justice is absolutely critical. It builds confidence and trust. So yes, I've been fairly well involved in pro bono work.
All right. Thank you so much, Ms. Mohammed. I'm now going to hand over to the rest of the commissioners to put questions to you.
Thank you, DCJ.
If there are any.
Thank you.
I will start with JP Mlambo.
Thank you, DCJ. Good morning, Advocate Mohammed.
Good morning, JP.
It's always good to see you.
Thank you so much.
From those days at Legal Aid South Africa?
Yes, we have a long, although we've had a huge break in between, but yes, I'm happy to have seen you again.
Yeah, I think let me start here, which I omitted to do with the previous candidate, to thank you for having been available to come and act in the division to assist us. Thank you very much.
It's been a fascinating experience, I'm thankful.
You've acted for, you say 40 weeks. My spreadsheet says 38 weeks, but that means we may have missed 2 weeks. That's fine. And I note that in those weeks, you've done a full 6 weeks in opposed motions. And I see there's a week in special motions.
That's correct.
The special motion, what did it deal with?
The special motion was actually an application for rescission of a judgment. And it traversed a very long history of an applicant who just would not leave his home. And he had extensive debates with banks and used various avenues to avoid being evicted and, of course, having to give up his home. So because it had a very long history and a lot of paper to get through, it's placed well within the special motions matter.
And how long did it take you to write that judgment?
DJP,
If you can remember, if you can't, it's fine. It's not material.
What I can tell you is we're certainly within the 3 month period that is allowed, yes. Most of my judgments are. I'm committed to that. I luckily am at a stage in my life where I've kind of managed time management. I'm pretty good at that, I think.
Yes. Now, in your stints in the opposed motions, I regard that as one of the difficult work areas because that's where most acting judges in particular find difficulty in producing judgments. And I can confirm that almost all your judgments were within 3 months. I think I've just seen one which was over 4 months.
Yes, I've had some difficulty on 2 or 3 matters, but they were for technical reasons, not necessarily that I couldn't make a decision on.
Yes. And it's not because you couldn't write those judgments, you could.
Yes.
Okay. How do you find your experience in the opposed motion court?
I must say I've been very well received by my colleagues. I do come from the bar, so often these are people I've interacted with at some point or passed by in courts, and all have been very respectful to me, have accepted findings that I might have made. Sometimes I've had to manage, do some administrative work with them, and they've been very, very well received.
Yeah, but in terms of the load you got, because I think Joburg is lucky in the sense that there's always an additional 1 or 2 pro bono judges. That lessens the load that gets spread, because the norm is about 12 files for that week. Am I correct?
Oh, yes. In fact, I wonder, with the 59 judgments that I've written, I think a lot of them have come out of the opposed court. Yes. It's a very busy division.
But you were able to handle the load?
I have.
Yeah.
Yes, I have.
And, I mean, you're a senior junior, am I correct?
I am, yes. I've been at the bar for 15 years and in the profession for about 28, 29 years.
Yeah. And at Legal Aid South Africa, you were involved in 1 or 2 matters that went to the Constitutional Court?
Yes, my unit supported, financed certain litigation. One of the matters was, it was an interlocutory matter related to the recognition of same-sex marriages. You must know then, JP, that it was a very new unit. So apart from the issue itself, it was having to sell it to a group of people where, you know, things were very new to them as well.
Yeah.
The other matter was the recognition, or rather a declaration from the Constitutional Court on the responsibility of who would be responsible for security at train stations.
Yes.
This was the Rail Commuter Corporation matter.
Yeah. Now, the DCJ took you through your experience, your professional history, and I've looked at it as well. You've also acted. You're a senior junior. You've been at the bar 15 years. You think that fully equips you to do the work in the division?
I'm confident that I am ready for this job. I think I have a developed eye, apart from having spent the time at your court, JP. I'm also bring a level of maturity.
Yes.
So I've sort of been around the block a little more, which has been useful. And essentially, JP, I want to share with you that almost 80% of my self-development has been, I paid for myself.
Yeah.
Having lost a parent pretty early in my life. So I think I have the resilience for it, yes.
Yeah. You've done most of your acting stints in Joburg, and you are at the bar there next to the High Court, am I correct?
JP, my bar...
The chambers.
My chambers are in, across from Sandton City.
Oh, okay.
I'm in Group 1.
Oh, you're one of
We were situated there, yes.
Group 1, okay. Thank you. Thank you, DCJ. No other questions? Thank you.
Thank you, JP. Premier, do you have questions for the candidate? Are you there?
Thank you so much, Deputy Chief Justice. No, I don't have a question for this candidate. Thank you so much.
Thank you. President Mulemela.
Good morning, Ms. Mohammed.
Good morning. Thank you. Behind the cameras.
Yes. I note that you are a very experienced advocate and you have had several acting stints, am I correct?
That is correct, yes.
I would imagine that as an advocate you have moved many ex parte applications.
I have moved some. I can't say that there are too many.
Yes. Have you had occasion to consider one while you were on the bench?
I have, I think, yes. I think I've done one, but I can't seem to, I won't remember the details.
Yes. Under what circumstances may such an order be granted?
The ex parte orders, of course, mean there's no notice. And I think the one that I might have considered, or rather heard of, or been advised on was in respect to preservation orders. If there's an application to preserve documents or monies that might be in a bank account, or those sorts of ex parte matters.
Yes, where it has been granted, what is the safeguard for the respondent?
The safeguard for the respondent, I think, ought to be that it is on an interim basis. That's the way I would grant such an order. And, you know, it's not as if he would lose all his monies. I mean, certainly issues come up in family environments as well, where spouses are looking for their share of 50% of a pension or whatever the case may be. But if it's granted on an interim order, interim basis, then the respondent then would have some security that he's got access to it.
Thank you, Ms. Mohammed.
I'm not sure if it answers your question.
Yes, it does.
Thank you.
Thank you, Ms. Mohammed. Thank you, DCJ.
Prof.
Thank you very much, DCJ. Good morning, Advocate.
Good morning, Commissioner.
I was quite interested in your exchange with the DCJ in respect of the, I will call it the child relocation judgment that you were speaking about, the children who ought to have been, yes.
Yes.
And I'm quite look, I'm not surprised that you are defending the judgment, but I think if one looks at it properly, perhaps there might be merit in the criticism. When I read it, and I just want to hear your view in respect of this. As I understand the case, this is a case where one of the parents wanted to remove the children from the country temporarily for the basis of cultural and religious aspects in Israel. But obviously there was a fear that that might be permanent. What I want to understand is when I look at the entire judgment, it seems like one, you do not necessarily deal with the constitutional rights that are at play, right to movement, you deal with that at paragraph 65, but it doesn't seem like you balance that with the right to culture and religion for the children. But even more concerning for me, and I understand that one might say, look, in cases like this, perhaps maybe the doctrine of subsidiarity might apply, and you are going to focus solely on the Children's Act. But on the basis of that, it doesn't seem like you deal with the provisions of the Children's Act. Because Section 12 of the Children's Act deals with cultural rights. Section 7 of the Children's Act also provides the definition of the best interest of the child, which includes cultural rights. I just want to understand from you, did you consult the provisions of the Children's Act and try to understand how they may assist you to come to, the conclusion might well have been right. I'm just concerned with the reasoning and the approach. Did you consult the Children's Act? Because it doesn't seem from the judgment that you have done so. I'm not sure what is your view in respect to that.
Commissioner, I don't know the exact paragraph, but I do remember that
Paragraph 54, you mentioned the Children's Act, but you mentioned it broadly. You're just, the Children's Act provides this. You don't even provide the section that deals with it. Paragraph 54.
Yes, I'm with you, Commissioner. So, Commissioner, your question is that I didn't deal with it sufficiently.
What I'm saying is it doesn't seem like you engaged perhaps maybe with the methodology of the Children's Act in respect of relocation cases quite broadly. I can take it further. Section 18.3, subsection Roman figure 3, deals with child relocation. So it doesn't seem like you grapple with the principles that are involved and the law in respect of the relocation of children. But even more concerning, it doesn't seem like the constitutional issues that arise, you actually deal with them. Perhaps maybe I might be wrong. I just want to give you a chance to give prefer view.
Commissioner, if I may place this judgment in context, it was delivered within a few days of having been heard. It was on an urgent basis. The evidence before me was that the tickets had already been purchased. And I understood that the dispute that was really preventing flying out of the country, etc., was really between two adults and the parents. And I looked at what was before me in terms of expert evidence, which at the time was not even complete, but the only real information before me. And that expert identified the personalities of both the parents. And this is the reason I heard the matter on the basis that the children have a right to cultural activity and to express their cultural beliefs and understanding and learning. And I understood that their grandparents, one of the children had not met his grandparent yet, and they were ailing grandparents. So this is why I think that the order ought to have been read against the judgment. But as far as the detail is concerned, I mean, it is what the judgment says. It is.
But under this circumstances, can you at least, at the base level, accept that maybe you ought to have engaged the Children's Act?
Commissioner, it's probably a style. Yes,
No, thank you
and one, I must say, I mean, there's always room for improvement on any judgment.
Thank you very much. Thank you very much,
Yes.
CJ.
CJ, may I please follow up on this?
Yes.
On this topic. Good morning, Ms. Mohammed. Good morning, Commissioner. Yes, it's not a style issue. I also have concerns about how you've dealt with this. What you do in this judgment, you start off by saying, this is brought on an urgent basis, and because it involves children, in the interest of the children, I've decided to hear it on an urgent basis. So you lay the foundation. And later on in the judgment, you say this matter could have been brought in the normal course, right? And I don't fault you for that. I can see the link that you make, that there was time to bring it in the normal course, but without deciding that it is urgent, you'll hear it anyway because it involves children. But nowhere in this judgment do you engage with what is in the interest of the children. In fact, I felt cheated or tricked because all you do in paragraph 65, which is how you come to your order, you say, I'm of the view that the constitutional rights to freedom of movement must prevail and that they must be assisted to travel to Israel on the identified dates for the period as set out in the papers. Nowhere in this judgment do you engage with what is in the interest of the child. So yes, the grandparents are ailing, they want to die, I beg your pardon. They are ailing and you're concerned that they might die. There's the reports which say that the father has got some problems, psychologists report, the mother, and all you say about the interest of the children or what superficially appears to be a discussion about the interest of the children is where you say they go because they have freedom of movement. But that's true for every child. Commissioner, if I can take you to paragraph 57.
Yes.
I've just identified that. Well, 56, if we can. Actually, a little earlier, I think it's 55, I say children are in their formative years and they will develop and actually grow within religious and whatever beliefs they may have to follow. And I'm of the view that I actually have considered the children. And I think at 58, I say that the court has to balance the interests against those of their parents and who appear to dislike one another despite their several years of living together. So I'm sorry if you think I might have forgotten about the children, but I seem to think that I have. However, as I say, one obviously in hindsight, one looks at ways to improve. Yes. No, I think all I'm asking for is that, what I'm asking is, do you accept it's not simply a question of style? And I think you make my point even further when you acknowledge that you deal with what you say. Is you dealing with the interests of the children in paragraph 56, where you say they will benefit from a visit to Israel, and then in the paragraph 65 that I referred you to, where you say they have freedom of movement. That's pretty much the considerations that you have made why these children should be allowed to travel. Commissioner, this is as far as I can take the point.
Thank you, TCJ.
Commissioner Singh?
Oh, thank you very much, DCJ, and good morning, Eric Mohammed.
Good morning.
Thank you. I just wanted to know, in your questionnaire with regard to the LPC and the Certificate of Good Standing, you've said something. Has there been any progress since you sent this application in to us?
This is about the LPC and the collection
Yes.
of sub-fees. Well, I haven't received another demand, so I assume that the records have been corrected. But I was just a bit concerned that it should not be something that prevents me from attending this interview.
Are you saying that you have received the certificate and have you submitted
I
that
do
to
want,
us?
yes, it's part of the pack.
Thank
yes.
you. Thank you. This is
Commissioner Matolo Dlebo?
Thank you, DCJ. Good morning, Advocate Mohammed.
Good morning, Commissioner.
You know, when I looked at your questionnaire, one of the things that I observed, 6.1.1, you say that you appeared mainly on behalf of the RAF. And when I looked at the percentage of your work, it's about 70% of personal injury.
That may be so.
And you go further to say the RAF is known for its tardiness and often, it briefs you late. Can you, taking into consideration the public onslaught against legal practitioners by the RAF, what does it mean, acting for the RAF? I mean, the fight between the legal practitioners and the RAF, in your mind, in your opinion, didn't it take a lot of work from practitioners or like yourself?
Sadly so, it has,
Can you just
Commissioner.
elaborate?
It has. There are a number of my colleagues I don't see any longer. A number of their livelihoods that have been under a lot of stress and strain. I, for one, have sought to find some of my colleagues and provide some level of emotional support if possible. It's been a very integral part of the lives of many, I must, with caution, but quite honestly say a lot of black practitioners at the bar and also the sidebar. It's been a source of a lot of work for them. I'm not sure if there's anything further that, Commissioner, you would like me to comment on?
No, thank you. I just wanted to at least to be, for the Commission to be aware of some of the difficulties, especially female practitioners are engaging in practice.
Commissioner, just to go on, I mean, the difficulties are just enormous. In fact, I think I might have been a little more diplomatic in the way I conveyed this, but yeah, the ramifications are absolutely serious. More importantly, the work provides opportunities to to really practice the law. And it is that is where we need to strengthen our skills, is in the regular practice of it. And that's where the confidence levels rise. So I do think that it has been, it's impacted rather greatly on a large number of practitioners, yes.
Thank you, DCJ.
Commissioner Kane.
Thank you, DCJ. Good morning, Ms. Mohammed.
Good morning, Commissioner.
As you're aware, there are 4 vacancies and a number of advocates competing for them. And one of the opportunities I'd like to provide you is an opportunity to explain the contribution you've made in your 15 or 16 years at the bar, because that would indicate a level of engagement with the legal community and service which may or may not distinguish you from the other candidates. Now, in your case, I noticed that you've had 2 pupils, but over a career of some 15 or 16 years, that doesn't seem like many to me. I don't see you having played any leadership roles in the bar or having been involved in its structures. And you have attended 2 courses at Wallenberg, but on both occasions as really a recipient of an investment into you as a result of the programs that take place there. So this question is your opportunity to explain what you've given back and your contribution within the bar.
Yes, Commissioner, I want to also place myself in context. My personality doesn't necessarily require me to be part of necessarily an organization, but that does not mean that I haven't contributed. Now, I have been a member of the RAF committee of the bar, and if I am not on any of the committees, I must, in all honesty, say it's not from not trying. And on a one-to-one basis, you can be assured that I am a very development person. I'm very committed to it. I have always been, well before I've even joined the bar. And in terms of the number of pupils I've had over the 15-year period, the reality is that briefing patterns have been so skewed that it doesn't serve me as counsel taking on a pupil and not being able to see the pupil through on various matters or various skills that ought to be shared. And I found that even in the very recent pupil that I've had, I think I've had a pupil last year, it was saddening for me that I couldn't, provide as much of practical skills that I would like to have had. Because at the end of the day, when I often sit on the bench now on a part-time basis or acting, and it's often a question of what is it that I put in order to inherit what I have before me. So I'm very committed to the development, if not in terms of having joined an organization or sat on a particular committee. It does not mean that I haven't been committed to development. I'm very committed. In fact, if you look at my career, I'm very committed to self-development. And as I say, it's often a matter of what have you sown is what you will reap. I'd be very excited to see very high levels of debate out there in front of me if ever I'm appointed as a judge. I'd be very excited to see high levels of debate even in written work as opposed to anything that involves physical appearance. And we need to do that. This is a legal system that is well worth looking after. And as I said, it's not from not having tried. I have contributed to the RAF committee. I've sat on the RAF committee for, I think somewhere in my application, I have indicated that. And I don't think that there is any member of the bar who will honestly tell you that I've turned them down for anything, at any point. In fact, I remember, to my credit, very soon after I had served pupillage, I would call the admin office at the bar and find out if there was any way that I could contribute to somebody's lunch. It was as bad as that 15 years back or 16 years back. And I think that, you know, if we need to call up people I'm sure they'd be able to support that. So as far as contribution is concerned, I don't think I've faltered in that, and I continue to do that. There's no reason not to. There's every reason to, actually.
Sorry, Deputy Chief Justice, I just want to follow up this because I'm really getting confused, and I'm not saying this disparagingly about your answer. The answer is, what have you contributed to the bar? That's a very simple answer. You can say, I did this, I did this, I did that. It's not, are you committed? It's not, are you willing? It's not, have you offered to buy someone lunch? It's what have you contributed to the bar? So just give us those things you've contributed.
Yes, I have not been part of any of the bar committees, no, except for a short time within the Road Accident Fund Committee that I was invited to join, and I attended each of the committee meetings, and if there were discussions to be had, I was part of that. Thank you, Commissioner, if I haven't answered the question initially.
DCJ, if I may follow up. Thank you. Ms. Hassim, you indicate then...
sorry, it's Ms. Mohammed.
Sorry, Ms. Mohammed.
That's all right.
Forgive me. It seems that you've had a dearth of opportunity then, which is obviously most regrettable, such that you can't even give pupils an appropriate training, but that you would like to be involved in high-level legal discourse on the bench. What also appears from your application is the matter that you consider to be of particular significance, which the form invites you to share with the Commission. And that, you say in 6.3, was an interlocutory application involving the sale of a motor vehicle. Now, it concerns me then to leave this discussion without asking you whether you really do have an appropriate level of experience to take on the position of High Court judge. If that is your experience at the bar, that it was lacking and that the most significant matter that you've actually handled involves the sale of a motor car in an interlocutory application.
Well, I don't think that, Commissioner, that it was really as simple as all that. It was basically an address to what would be at that time a very respected judge and continues to be, on the aspect of the safeguards within the National Credit Act that this particular defendant or respondent sought to evade and overlook. And if you look at through my application, I'm very, very committed to consumer rights. And these safeguards that are built into the National Credit Act were simply ignored. And that was the real crux of the debate. Interlocutory or main is you know, obviously there's a distinction. But it certainly is a valuable legal argument that one can put in, even at an interlocutory level. And I think that was really what I was trying to convey to the judge at the time. Yes, I suppose one can look at the application and consider it to be quite limited in terms of exposure as a practitioner. But the 41 weeks that I have sat in as acting judge has just been a phenomenal experience. More so, it's been a very revealing experience as a black woman and a practitioner, in the sense that if you've mastered what would be the principles, and we continue to do that, but in doing so, then you develop other skills, like listening skills, like analytical skills. And I believe I have those. And besides my time at the bar, you must not forget that I also was very involved in forensic work in the various jobs that I've held. I also come in with management experience and ability, which is critical in the job of a judge. So, Commissioner, it's as far as I can take it. But I do also want to tell you in my defense, I'm here to sell myself, of course, but in my defense, where I was unable to assist a pupil, I have the kind of group that was open and willing to offer a seat in their chamber for my pupil. And it has happened. And often my pupil would return and we would have a discussion. The other things that that probably don't appear in my application is that through the 41 weeks, and some of them have been on a virtual platform, I've invited pupils in my group to sit in with me, and we would have that discussion on the matter and how one would go about it procedurally and based on the substantive law. And so I think I have the confidence that I might be able to pull this off, if one can use the term.
Yes, thank you. Thank you.
Yeah. Commissioner Lutyens?
Thank you, CJ. This is just a quick one. I just want to focus on sentencing. Sentencing.
Yes.
How the court must approach sentencing in circumstances where it is dealing with the minimum sentences, how you should approach the sentencing.
Well, if we've identified that the crime committed falls within the Minimum Sentences Act, the court is obliged to apply the Minimum Sentences Act. Unless there are some exceptional circumstances that this particular accused presents, and of course the court would look at that. But in terms of applying the Act, that is, essentially it has a purpose.
Commissioner Lucas?
Thank you, DCJ. No, I'm sorry, someone just sent me now a disturbing WhatsApp about someone that can't bury the parent because she was blacklisted during COVID. So I was now a bit distracted. I'm sorry, and I'm now asking possibly the former question to the correct candidate. Good morning, Advocate.
Good morning, Commissioner.
I think the other question is fine, because I noticed in your, and you mentioned also something about the trust deficit that is actually existing currently in the country, but also the issue of discrimination against other people, like people that are disabled and so on. And I see you are involved in a what is it, Living Links or
That's
something?
correct, yes.
I would have loved to ask you the other question, but we are allowed one question, and this seems to be more closer to myself. It's about how successful is this program that you are involved in? And what is your experience with regards to particularly discrimination in the workplace with regards to issues of disability?
Commissioner, it's a program that is working wonders. I hope to continue with my contributions to the development of the young people. The young people at this organization are all across the board of all races, genders, and economic backgrounds. And that, for me, already is a very valuable pot where there is a good cross-pollination of experiences across the children, or young people, not all children. And yes, there are many programs that the organization is involved in with corporate companies to help develop the skills of young people so that they become independent people. Perhaps, and with a full appreciation for some of their disabilities and how they can actually get around those disabilities. So I'm very excited about this organization. I'm very pleased to have been invited to be part of this board. It is well managed. We need to integrate perhaps a little more, and I think that there's room for that. Members of our board are also well integrated across genders and the races. So there's a grasp on what is on the ground that comes from the board members themselves. So it's a very promising organization.
If I may, DCJ, and just for a follow-up, I was just thinking in this, what is the reach of this organization? Is it just in Gauteng, or what is your plans with regards to?
There is Commissioner, there is an office out in Cape Town as well, and they do fairly well. It's also a very well-established part of the organization. And in fact, very recently, they've managed to raise a great deal of donor money independently, and that's a very promising thing, given that the difficult economic times we find ourselves in, whether it is in the country or globally. So accessing donor funds is a challenge, and they've been doing well. Yes.
Thank you, DCJ.
Commissioners on the virtual platform, do you have questions for the candidate?
No questions.
Go ahead, Commissioner Bennett.
No questions.
Oh, no. Okay. Thank you. Well, this is the end of your interview, Ms. Mohammed. Thank you very much for making yourself available for the vacancy.
Thank you, DCJ. It's been a good experience, and thank you to the Commission.
Excused. Colleagues, we are well past our scheduled tea break. I don't know if you want to break off now for a few minutes, then come back. Okay. The time is 11:21. Shall we come back at past? Is that fine? At past, the candidate will be sitting there, so no lingering.
Good morning, TCJ and the rest of the commissioners.
How are you?
I'm fine, thanks.
Good. Just looking at your CV here, you hold 3 degrees from Wits, a BA, an LLB, and an LLM.
That's correct, TCJ.
What was the subject specialty of your LLM?
It was a competition law, broadcasting, media, and space law.
Oh, right. You are at the Johannesburg bar since when?
2005.
2005.
Yes.
Right. And what did you do by way of work before that?
It's a long history, TCJ, but immediately...
Just a short summary
before
in
coming
broad
to
strokes.
before coming to the bar, I came straight from varsity. I think I worked for 2 years as a tutor, and then I came to do pupillage.
Right. What kind of a practice do you run? Is it a general practice, or have you carved a niche, a certain niche for yourself?
Essentially, it's a general practice, TCJ, but I tend to specialize or get more work on certain areas of law, like criminal law and medical malpractice, then a little bit of the rest that I've mentioned in my application.
Right. When I asked about your employment history, you didn't mention that you were once a golf caddy.
That's why I said it's a long history. I will have to start as a farm worker. And
Yeah, you've done a whole lot of things.
Yes.
Everywhere.
Yes.
Well, beats character. You have acted as a judge in the Gauteng division, not so?
That's correct, TCJ.
For how long?
I think I've got the spreadsheet there, maybe 13 or 14 weeks now.
Okay. In all?
The JP will correct me with the stats, but I had the last full term in the third term.
This past third term?
Yes.
Okay.
And 1 week during recess.
Yes.
So my acting stint ended on the 22nd of September.
And you have managed to pen some judgments in that time?
Yes, but I still have some reserve judgments, and some of the reserve judgments are within the full court. I was a member of a full court and a full bench.
Yeah, but those judgments were recently reserved. They're not old, not so?
No, they are not even more than a month.
Yes. Do you have any reported judgments?
No.
Hopefully one will land in the blue and green books. All right. Let's see. I'm just looking for something I wanted to ask you about. Oh yeah, I wanted to ask you about your the work you do as a lecturer at the bar, right, a pupil teacher.
Oh, yes, TCJ, I've been a lecturer in civil trials, probably for the past 7 or 8 years now. Yes.
Right. Okay.
So I give a lecture on various topics on civil trials, but primarily on cross-examination. So if some of the pupils are not good in cross-examination, you can blame it. You can blame me, TCJ.
Right. All right. I'll leave it here and hand over to the other commissioners to put questions to you if they have any. Judge President Mlambo.
Thank you very much, DCJ. Advocate Mkabela, good morning.
Morning, GP.
I think I also want to start by thanking you for having availed yourself to come and act in the division now and then.
Thank you.
We appreciate it. My spreadsheet says you've acted for a total of 17 weeks. In the earlier years, I think in 2019, 2020, and 2021, those were pro bono weeks, am I correct?
That's correct.
Yeah, thank you very much. And thanks for that, because the pro bono assistance you've seen, it helps the judges in the opposed motion loads, case roles, deal with the workload.
Yes.
So thank you very much for having availed yourself. I see that despite your short acting stint, you've done 6 weeks in the opposed motion court.
Yes.
How did you find that?
I've always been put at the opposed motion court.
You're a silk. That's where we should put you. What do you think? But how did you manage with the work?
No, I did manage JP. It's quite interesting. One is exposed to a variety of areas, even
Yes.
areas where one doesn't practice in.
Yes. But did you struggle? Did you,
No, not at all, thanks to the competent counsel before me, because sometimes it is very helpful to get good counsel where heads are well drafted and the submission is very crisp and to the point.
Yeah. I have not yet put you in the criminal trial role because of the limited number of times you've been appointed. But I'm told you do a lot of work as counsel in that field. Is that correct?
Yes, JP, that's correct. That's the only work that I haven't done since acting. But
Yeah.
I've done almost everything now, civil trials.
Yeah. You've done 2 weeks in the agent court.
Yes.
How did you find that?
Very demanding, and it is important to even grant an order, maybe reserve reasons so that the parties can get on with their lives.
Yeah. And how long did it take you to finish the judgments you picked up, either in the opposed motion court when you sat there or in the agent court? I mean, you can give us an average time, whether it took you a week, it took you 6 months, or it took you a month.
I tended to prioritize the agent court judgments. Most of them I gave extempore judgments or draft orders,
Yes.
made an order of court and reserved reasons.
Yeah.
And maybe in a day or two, in respect of the agent court.
Yeah.
And in respect of the opposed motion, maybe a month or so.
Yeah. Your list of judgments that you've given me suggests that you've done a total of, is it 13 judgments or more? I think it's 13.
13 so far.
13 so far, yes, yes. But looking at that, as I say, you've only acted for about 17 weeks. You're a silk. You've been in practice. Your acting stints the judgments you've written, the allocations you've had, you feel confident that that has prepared you?
I feel confident that it has prepared me, JP, taking into account that I was aware that I haven't acted for long and then I don't have so many judgments. That is the reason why I then attended the aspirant judges training.
Yes.
To ameliorate the lack of a vast acting stint. And as you are aware, the aspirant judges training is quite robust, and after that, I feel confident that I'm ready, JP.
Right, okay. No, thank you very much, DCJ. I'm happy with this candidate.
Thank you, JP. Premier?
Thank you so much. If JP is happy, I'm also happy, Deputy Chief Justice.
All right.
Truly appreciate it. Thank you so much.
Minister?
DCJ, I'm also happy.
I see that the JP has captured you. Professor Marumogai?
Thank you very much, DCJ. I must note as well that I do know Advocate Mkhabela. And sometimes one has to disclose, I'm not sure if I need to disclose this, but his wife is actually a good friend of mine. So I'm not really sure if this is something that needs to be disclosed, but to the extent to which it has to be, I will disclose that. Advocate Mkhabela, I just want to ask you, given your knowledge of criminal law, and if you are successful, obviously you will be able to go to that particular role. And ever since I joined this body, I've seen candidates struggling, those who have failed and those who have been successful, struggling with what I'm going to put to you. And I just want clarity, so that we can get some sense of clarity as to how this thing is actually approached. There seems to be some confusion as to the test that needs to be applied when a person is applying for discharge in terms of Section 174. I just want you to set out that test quite clearly, and then go over and just explain whether, if the application is refused, whether that application can actually be appealed against. Thank you very much.
Thank you. At the conclusion of the trial, we normally ask for a discharge, or counsel will ask for a discharge in terms of that section if there is no sufficient evidence before the court, and if the application is granted, then the accused will walk. As to whether it is appealable, I think it's debatable. But the normal cause is that the prosecution doesn't come back to reinstate those charges.
I guess I'm more concerned about the actual test, because sometimes there are people who believe that the state has to prove its case beyond a reasonable doubt at that stage. So I'm just concerned about the test that needs to be applied.
The test, as far as I know, is that the presiding officer must be satisfied that there is no prima facie evidence that is before him or her in order to grant a discharge. It doesn't need to determine whether the state has proven its case beyond reasonable doubt. At that stage, the test of reasonable doubt doesn't apply.
Thank you very much, CJ. Deputy Chief Justice.
Thank you, DCJ. Good morning, Advocate.
Good morning, Commissioner.
Yes. I want you to allay my fear. You, according to you, you don't have any reported judgment. 2, GCB is having a concern about the fact that your judgment are riddled with spelling and grammatical errors, some of them. And the LSAA says that you lack the experience. Just allay my fear and respond to all these questions. Yeah, thanks.
Thank you, Commissioner. As far as the criticism about the grammar and spelling, I've noted the concern. They say some of his judgments have grammatical errors or spelling mistakes. It may have happened that I didn't notice that, but I would urge you to consider that even the attached judgment, that's not a prevalent misfortune on my part. Maybe it may have been one or two where there were maybe spelling mistakes. As far as the concern about the concern by the Law Society, if I can just go there, if you allow me, there is a paragraph that I wanted to direct your attention. In fact, in the same criticism I recalled, they also indicated that I show knowledge of the law in the judgment that I've written. And then at the conclusion, then they say I can benefit by a further acting stint. That's why as I've mentioned earlier, I was cognizant of that. That is why I attended the judges aspirant training to ameliorate that lack of experience. And even notwithstanding my lack of many acting stints, there is no criticism about the substance of my judgment. So I will urge you to take into account that prior to commencing acting, I had accumulated vast experience as a High Court practitioner.
Okay, no, it's okay.
Yes.
Just a quick one, the last one, DCJ. The last one would be, in your view, give me just three, not elaborate, just three qualities of a good judge.
One, I would say that is a judge that is open-minded when you approach your case. The second one, I said to be courteous to the parties. And the third one is that you should give reasons for your judgment.
Okay, no, it's okay. What about this old adage, I'm sober like a judge?
It goes to the open-mindedness because it's difficult to be open-mindedness if you are not sober.
Okay, thanks.
DCJ, just want to follow up on Mr. Dodo, not the open-minded part. I just want to make sure, Mr. Mkabela, that we don't do you injustice. I've looked at the GCB paragraph 9.1 of the report. What it actually says is the candidate's judgments indicate that he has a good command of English and is able to communicate his thoughts both clearly and effectively. And then it says, unfortunately, some of his judgments contain spelling or grammatical errors, so you end up not knowing if it's spelling or grammar, or both, suggesting inadequate attention to proofreading. Now, I, speaking for myself, have read 3 of these judgments. I couldn't pick up, one of them actually is written with Judge Mayer, who's endorsed it as well, who's a senior judge. I couldn't actually pick up the grammar or the spelling or the proofreading mistake that they were talking about. When, especially to say riddled, when something is riddled, it means from beginning to end, it's full of these things. So, and then the problem I have with that is that it also doesn't say, it would be better for the GCB to actually say this judgment contains the following spelling errors, then paragraph 2, paragraph 3, then we can go to those paragraphs and ask you meaningfully to explain. But it seems that it's a general complaint that basically you don't proofread your judgments. So maybe if you want to reflect on that, you can do that now. But I thought instead of us leaving this hanging, you should have a chance to attend to it.
Yes, thank you, Commissioner. I also struggled to identify the particular judgment. I would also have wished to have been, that it would have been helpful if that particular judgment was mentioned. But the criticism that I don't proofread, it's not borne by the evidence, because otherwise all these judgments that I've attached will be replete with these grammatical errors that they are alluding to.
Commissioner Singh?
Thank you very much, Deputy Chief Justice, and good morning, Advocate Mkabela.
Morning, Commissioner.
I think when the DCJ asked you earlier on about your career and your work experience, I mean, it's here for us to read. But you are aware that we are on a public platform. The JSC is advertised widely. And we've got a number of journalists here. We have a number of aspiring law students, aspiring senior counsels, and judges as well. But I must say I'm truly inspired by where you started and where you are today. From being, somebody harvesting tobacco leaves, to being a golf caddy, to being a Malaysia in the mines, and then working as a security guard, and then cash building supplies, etc., etc. I just want to know, for the benefit of the general public out there and these aspiring students that are here and also on the platform, what was it that triggered your passion in studying law and rising to the heights that you are at today? Because I think it's important for South Africans to know that there's always hope for any individual, and I think you are an expression of that hope. So if you can just share a little bit of that with us. Thank you.
Thank you, Commissioner. It was the desire to contribute to society, and I realized that if I get some education, I'll be able to improve my situation. And it was also triggered by the poverty that I was born into. And I realized that to escape it, education was the key for me. And also that if I can just add to those who may be in the similar circumstances, is the desire to succeed, the ambition to succeed. That's what drove me all along.
Why law?
Law, because law is an instrument that I can effect change into society. And you will recall that during my upbringing, it was at the height of apartheid. And I realized that if I can make my contribution, I can use law as a vehicle, because you will appreciate that most of the injustice were legislated by the apartheid government.
Thank you very much. I think if this doesn't inspire other young people, nothing will. Thank you, DCJ.
Commissioner Moiman?
Thank you, DCJ. Good morning, Advocate Mkabela.
Morning, Commissioner.
Thank you. Just taking from 6.2, where there is a reflection on 6.2.2 and 6.2.3, the proportion of litigation in administrative law and constitutional law. I just need to get a sense in terms of your appreciation of transformative justice, given the importance of the importance that we attached to the role of the courts
in ensuring that the Chapter 2 of our Constitution is much more realizable, particularly given the fact that there's been a number of cases where government was found wanting in terms of either the rule of law and also being found to have acted unconstitutionally by not taking the right decisions, which ultimately were set aside by a court of law. Can you just probably give us comfort in terms of your appreciation of transformative justice, because we expect more from the court in terms of remedying those situations where the government is found wanting? Thank you.
Thank you, Commissioner. Commissioner, the starting point is that in this year, 2023, our constitutional jurisprudence has grown up since the inception of the Constitution. And there is vast case law dealing with the stamping of abuse of power attributed to the organ of state. And administrative law, whether you before you approach the court on the basis of parsia or on the basis of the principle of legality, it is important for the courts to make sure that any power that is exercised by any organ of state is grounded in the Constitution, and to the extent that it is outside that, any court is bound to declare that conduct invalid and set it aside. So I'm very alive to those dynamics, Commissioner.
Thank you, Advocate Mkawala. Thank you, DCJ.
Commissioner Balwe. Yeah, it's your turn.
Sorry. Thank you, DCJ. Good morning, Mr. Mkawala.
Morning, Commissioner.
Yes, if I may also declare, I was in the same pupillage class as you, and we were group members in Group 621 together for quite a while.
Yes.
Now, some of the questions that have been raised with you are about getting comfort about your experience in other areas of the law. Now, because in your application you indicate that your main areas of practice are criminal law and medical negligence. Those are the highest that you've got, and something that the GCB comments about. And I guess I sit in some advantageous position that I was the chairperson of the Bar and the Silks Committee when you applied for Silk. So I know that this is an issue that also came up at that point, that your practice was overwhelmingly criminal. Now, to what extent, and you took Silk in 2022, so there's not much time that has passed since then, and yet in your application, you've given us 3 judgments, 2 written by you. I think it's 3, 2 written by you. But just from that, one doesn't get a sense of your experience and your comfort with other areas of law other than criminal and medical negligence. And I think it also doesn't assist that in your questionnaire, there's a question where you are asked whether during your acting stints, did you sit in both civil and criminal matters, and then you say no. So that sort of adds to further confusion or lack of clarity about what in fact is your breadth of comfort, experience, and knowledge of other areas of the law, because it's not apparent from your application. Can you just perhaps speak more to that?
Thank you, Commissioner. Just one correction. The 3 judgments are all written by me. The other judge just concurred.
Yes, I accept that.
Yes.
I accept that it's 2 of you, he concurred.
Yes. In your question about being comfortable about other areas of law, you can see from the judgment that are attached, none of them pertains to medical negligence or criminal. And even the reserve judgments that I have, none of them are criminal, except one full court criminal appeal. The rest are commercial. So I'm quite comfortable in all areas of law. I have indicated that the major ones are the criminal and medical negligence. That does not mean I don't do other areas of law. It was going to be cumbersome to state everything that I do, but I was just giving a general picture. I am comfortable in respect of other areas of law, and the aspirant judges training was also helpful. You have judges that are specializing in these commercial matters that took us through. And in addition, if I may add, I'm a quick learner, as one of my letter of support indicated. I'm able to quickly assess what the issues are and get to grips with what I need to decide.
Yes.
So it's not a problem.
Okay, I guess what I'm wanting to put to you is a comment such as this from the GCB, where it says the extent of the candidate's knowledge of constitutional law is unclear. There's nothing in your application that you've presented to us, including the judgments, that provides clarity. I hear what you're saying, but not on the application as it stands, because they don't traverse those areas, your judgments. They don't traverse constitutional issues.
Yes, the judgment that are attached do not traverse constitutional issues.
All right. Thank you, Mr. Mkabela. Thank you, TCJ.
Thank you, Commissioner.
Could I just follow up on this, because maybe I also need some clarity. See, the problem, I think, Mr. Mkabela, I don't want to speak for Advocate Baloyi, but I've got a separate issue that is as a result of what she's asking. So if you are a senior counsel appearing, I can understand saying, listen, you know, I've acted for one term, so I've got 3 judgments. That's fine, there's no problem there. But I can say to the commission, don't worry about it, because I've appeared 5 times at the SCA on constitutional issues, or I've appeared 10 times at the High Court on constitutional issues. So I'm familiar with the subject as counsel. So I think that's the kind of compensatory factor, if I can put it, that I would be interested in flowing from the question from Commissioner Baloyi.
Thank you, Commissioner. What I was trying to impress upon Commissioner Baloyi is that the mere fact that I didn't appear in a constitutional court, in court on a constitutional matter doesn't follow that I'm not alive to constitutional law. Because the Constitution is the supreme law of the country. In each and every matter, one must be alive to the constitutional provisions that may be applicable.
No, sorry, Mr. Mkabela. What we want is evidence, not a claim. That's why I'm saying, you could say, I'm compensating for absence of judgments by experience. That's what I'm trying to get to. And you can say to us, listen, don't worry, I've been at the Concord, I've been at the SCA, or I've been at the High Court, anything that would make us to compensate for your lack of written judgments in constitutional law. Is there any such? Just tell us, because you have a chance now to tell us this information, because it's not apparent from your application.
If you look at my CV, I've been in the High Court for quite some time, litigating in the High Courts. Some of the matters involve constitutional issues, but I don't have judgments to that effect. And as far as appearing in the Constitutional Court, I didn't have those opportunities during my practice.
Are you aware, have you finished, Mr. Mqaitwa?
Yes, TCJ, sorry, thank you.
Are you aware of any reported judgments in matters in which you appeared as counsel? Are there any at all?
I'm aware of an SCA judgment where I appeared with Advocate Sony SC.
Do you recall the particulars of the matter?
Yes, it was a medical negligence matter where the issues of general damages were at issue. The plaintiff or the appellant wasn't happy with the amount that was awarded by the trial court.
Were you successful in that appeal?
We were justifying, we were acting, we were not successful because we were justifying the award and the SCA increased it.
Right. Any questions from the virtual platform, colleagues? No.
No questions, DC.
No, thank you, Deputy Chief Justice.
Thank you. We have reached the end of your interview, Mr. Mkabela.
Thank you.
Thank you for taking the time to come here and for making yourself available for this vacancy. And good luck.
Thank you, TCJ.
You're excused. Good day, Mr. Muki. Did I pronounce your name correctly?
Good afternoon, Deputy Chief Justice. It's Mooki.
Oh my goodness, Muoki.
Muoki.
Please forgive me. All right. I see that you're still being handed documents. Have you settled in?
Yes, I believe I'm settled.
All right. How are you?
I'm well, thank you very much.
All right. You obtained a Bachelor of Science in Immunology and Microbiology, then went on to do a Master of Science in Physiology. But here you are today. How did you change course? What happened?
Right, well, perhaps I've come full circle in that on finishing matric, I got admitted to Natal Medical School and to the University of Botswana. I parents didn't have funds for me to go to Natal, so I ended up registering for the BUris degree at UNIBA. So perhaps it's in that sense that I've come full circle back to the law.
All right. Well, you started out as an attorney.
Yes. I practiced as an attorney for 2 years, and thereafter I was a senior legal advisor at one of the banks, but that was for a very short period.
Yeah. What changed your mind so quickly?
I was always minded to go to the bar at some point, and it was made known when I was working as at the bank that pupillage was going to change from 6 months to a year, and I took the view at the time that if I didn't go to the bar now, I would never go to the bar. So that is the reason why I left my employment with the bank and came to the bar through pupillage.
All right. And you have been at the Joburg Bar since December 2003?
Yes.
Okay. You have acted as a judge since 2012, I see.
Yes, I started my sessions at the Labour Court, and I believe that cumulatively I would have at least 3 full terms in total at the Labour Court, and then I have had further sessions in the High Court.
Mm-hmm. You had a longish stint at the Labour Court, 3 years, during which you managed to produce 20 judgments?
Yes, I did deliver a number of judgments, some of which are reported.
Yes. And how long have you acted at the High Court?
2 full terms, and I believe, I couldn't quite get my numbers right, I believe perhaps 5 additional weeks.
Yeah, well, we do have a spreadsheet from JP Mlambo, so we can check on that. Did you manage to produce written judgments in the High Court?
Yes, I have, and they are included in my pack.
Yes. Any of them reported?
Not in the traditional law reports, but I do have a number of judgments from the Labour Court which are reported in the traditional law reports.
When was your last acting stint in the High Court?
The very past term. I had a full term in Pretoria.
Do you have any leftover, any reserved judgments?
I do. I have an outstanding judgment from the 3rd Court. It's a rather involved matter which is taxing, but I do believe that it's within the 3-month period. So,
yeah. You list a number of fields of practice that you've had the opportunity to dabble in. It's a wide range: public law, labor law, medical negligence, commercial law, competition law. But you state that you have not done any criminal work as a lawyer, well, as a practitioner.
Yes, I haven't practiced in a criminal court at all. In my recent stint, I sat in a number of appeals, criminal appeals. But as far as practice is concerned, I have not practiced in the criminal courts.
How did you fare in the criminal work at the High Court now?
Well, in an appeal, really, it's a matter of law. So one has to read up on the law, and I did not find it particularly taxing.
But you've not had an opportunity to run a criminal trial?
No.
Okay. You have done a few other things. You chaired the Water Tribunal at some stage.
Yes, well, I sent through a correction. I was a member of the panel.
Sorry, my mistake. Yeah, you were a member.
Yes.
When was that?
2000 and believe 2004 to about 2007. So it was more than 3 years. And as I recall, that could have been the first water tribunal that was constituted given the new act.
Did you write any judgments there?
Yes, I wrote a number of rulings, and some of which are also in the pack.
Yeah. You were awarded Silk in 2018.
Yes.
Right. All right. I will leave it here, Mr. Mwoki, and hand over to the other commissioners to put questions to you. Judge President Mlambo.
Thank you, DCJ. Good afternoon, Advocate Moogi.
Good afternoon, Judge President.
You've never corrected me pronouncing your surname incorrectly.
Perhaps my ears deceived me. I'm known to be particular with how my name is said. So if I thought that it was not said properly, I'm certain I would have let you know.
I think I start where I start with other candidates to thank you for having come in the division to aid and assist us. And you've seen that we do need an extra pair of hands. Am I correct?
That is so.
Thank you. Just quickly through your acting stints, according to the information I've gathered, you've had a total of 29 weeks in the labor court, which is the 3 terms you mentioned. And the bulk of that has been in the urgent court. That's 7 full weeks, and in the opposed motions court, which is 9 weeks. Am I correct?
Yes.
Thank you. You've done work here and there in the other areas like trials, and you've had leave to appeal applications. But in the High Court, I see you've done 4 weeks in the opposed motion court, and you've done 2 weeks in the urgent court as well as a special motion. That's the one you mentioned.
Yes.
That you say you found taxing.
Yes.
Now, you've written a number of judgments as well, and have you written a judgment that was more than 6 months old?
Certainly not in the High Court.
Yes.
It's very possible that there could be one such judgment during my session in the Labour Court.
I see, yeah. But in your varied experience, I mean, you're Silk since 2018. You've appeared in the High Court, obviously. You appeared in the SCA in Concord?
I have appeared. I appeared in the Supreme Court of Appeal once. I appeared twice in the Constitutional Court. And if I may add, as far as the Constitutional Court appearance is concerned, I had been at the bar for 2 years before my first appearance.
Yes.
At the Constitutional Court, but those briefs are far and few in between.
Yes, yes. And I've looked at your list of judgments. Despite, I think it's what, 29 weeks plus 21 weeks. That's quite some time, and it's quite a number of judgments that you've penned in both courts.
Yes.
Then you say 3 of them are reported in is that the Industrial Law Journal in the Labour Court?
I could be more than 3, but yes, I think a decent number from my session in the Labour Court are reported in the traditional law report.
Yeah. Have you found the work manageable in the High Court? Because that's where you are focused. I mean, traditionally, you get about 12 to 14 files for the week in the opposed motion. And those are cases that have counsel on both sides, sometimes more than that. How have you found that work?
I found the work manageable, and I must say that my sessions at the Labour Court stood me in good stead. The court in Braamfontein is very busy, and so it wasn't that a surprise for me as such when I came to the High Court and got allocated matters in your postcode. But one has to say that it is a taxing court.
And the agent court in the High Court? I mean, how did you find that? The tempo?
It helps that one was at the bar. So you have a sense of what needs to be dealt with. And one would have developed a facility for identifying issues that require resolution. And I think that ability, despite it being the urgent court, it doesn't make the court forbidding.
Yeah, okay. And you feel, especially, as you say, the stints in the labor court stood you in good stead when you came to the High Court, and you feel you can handle the work on an ongoing basis, and that's why you're here.
I believe I can.
Thank you. Thank you very much, TCJ. I'm happy.
Oh, Premier, do you have questions for the candidate?
Yes, if you don't mind, TCJ.
Go ahead.
Good day, I advocate Moki.
Good afternoon, Premier.
And I might be wrong, advocate, according to your CV, I'm not seeing any element of community upliftment, either in the circle of youth development, church, sport, or any sector of our society. Does this mean that you might be dealing with our communities and understanding what is happening in our communities?
Premier, I didn't quite, the line is not, it's not ideal, but I seem to understand you to be asking about my involvement in community life. I believe that I believe that I have always been involved in community life. It might not be through, for lack of a better description, the traditional sense of what that would entail. I consider that I do have a care for public life. There are a number of organizations which I've listed in my pack, which I've been involved in, and I do believe that those also are an expression of a person who has an interest in public life.
Thanks, TCJ. I'm fine, thank you.
Thank you, Premier. Minister? Commissioner Mulemela?
Thank you, DCJ. Good afternoon, Mr. Muoki.
Good afternoon, Madam President.
Yes, thank you. I listened to the exchange between you and the JP, and I'm encouraged by the fact that you have presided over matters in the Asian court. Did you, on any occasion, have to deal with an ex parte application?
Not as counsel, but...
No, I mean...
As a judge.
As a judge, yes.
Yes.
Did you have to consider it?
Yes, I had one such matter when I sat at the court in Johannesburg in the past year.
What kind of relief was sought?
The relief was to secure evidence, was to preserve evidence.
Yes, and what order did you grant?
Well, that is the order that I granted. The substance of the order was that the applicant, with the protections that traditionally would be included, that the applicant was permitted to enter the premises of the particular respondent through the aid of the sheriff. This happened to be in an Anton pillar with the aid of a sheriff and a designated attorney, and they were authorized to secure the evidence. There were protections as to where what could be done with the evidence and where it could be put.
Would you describe it as a run-of-the-mill order that is granted, or is it granted only in exceptional circumstances?
Well, it's not run-of-the-mill. I wouldn't quite say it's exceptional circumstances as such. It's a unique type of relief because it goes to preservation of evidence. But of course, it being ex parte, that is to say, without notice to a respondent, and what will be before the court will be what the applicant says. There are a number of important obligations as to disclosure by the applicant, and so the court has to be satisfied that, given the basic principle of a court having to make a decision with reference to what both parties have to say, in this instance, there will be only one party. So that when the court makes that order, the court will have to be satisfied that there is no abuse of the court process or an injustice. And when rendering the order, of course, it's not final, and the other party would have occasion in due course to have their say in court.
Thank you very much, Mr. Moki. Thank you, DCJ.
Commissioner Marumagay.
Thank you very much, DCJ. Good morning, Mr. Moki.
Good afternoon, Professor.
Oh, good afternoon. I beg your pardon. Should you be successful, and you are most likely also to be put into the urgent court, and of late we see a lot of applications being dismissed where judges are saying this is self-imposed agency, and it seems like while at times practitioners take chances, but sometimes you find that there are meritorious sort of applications which, even though they are meritorious, they may not be meeting the test for agency. I just want to get your sense as to what is the test for agency? What does one have to satisfy in order for you as a judge to grant an order on an urgent basis?
The law in this division certainly has come to be accepted to be as set out in the ISROC matter, and there the court will ask whether the applicant may not get recourse in due course. That, in substance, really would be the test as far as the aspect of agency is concerned.
That's where you are going to leave it.
I beg your pardon?
I'm saying that's where you are going to leave it. I was just thinking that perhaps maybe you'll take me through, is it rule 612?
Well, yes, so of course there are the other requirements. I thought you wanted to know on the agency aspect to what a court will have regard to.
But surely that will be part of the inquiry. I just want to understand when I approach you and I come before you and I say that this matter is urgent, what do I need to prove for me to succeed? I mean, do I just have to show you that there will be or there will not be relief in due course? Is that the only thing that I need to deal with?
Well, no, of course, the other usual related part would be a party may seek, for example, an interdict, and then there you will ask whether the applicant is seeking final relief or is this an interim relief. And if that be the case, depending on whether it's final or interim, one would apply the rules as to one or the other.
No, that's fine. Thank you very much, DCJ.
Follow up, Justice, quickly on this. Just a follow-up on this. I'm not too sure. Are you saying in an urgent application, the applicant must show that there will be no, he would not be afforded remedy in due course? Well, I don't get what.
Yes. basically, because of the nature of the court process and because of the demands in the court, the sense of fairness to all litigants is that one must be in the queue. So when a litigant comes and says, my matter is urgent, that litigant has to justify to the court why the court must allow that litigant to go to the front of the queue in circumstances where there are other litigants whose matters have been pending for a very long time, but without being allocated a hearing. So it's a form of control that the court has.
All right. Just on this, and then if the court is of the view that the matter is not urgent, can it dismiss that application for lack of urgency?
No, the court can't. If it's not urgent, the court is not going to hear the matter. It can't hear the matter.
Commissioner King?
Thank you, DCJ. Good afternoon, Ms. Morki.
Good afternoon, Commissioner.
I have given an opportunity to the other members of the bar, that is, to give the Commission some indication of the public spirited work they've done or service to the community and the bar itself as a way of indicating your involvement with community, because it may be a distinguishing feature between some of the applicants that are competing for only 4 vacancies. I see that you have served as a member of the professional subcommittee of the Johannesburg Bar, and you've also been an editor of a journal called Perspective at the Cape Town Law School. Perhaps you could give us some indication of the time commitment to the professional subcommittee and what your contribution was there, or whether there's any other significant contribution that we should know about.
Yes, Perspective was what we thought at the time was a radical publication in the law school, which was meant to be independent of the other publication, which was the one put up by the faculty. As far as the bar is concerned, I like to believe that I have been involved in the life of the bar since I joined the bar, not only through as a member of the professional committee. I have always been involved in the training of pupils. I'm a lecturer in the bar's advocacy training program, which is an enterprise. Don't quite recall whether it's once or twice a year, but annually the bar has allocates time for trainers and judges to attend at the bar for the training of pupils. And I like to believe that outside of the bar as an institution as such, within my practice, that I have retained an interest in the life of baby juniors. They see me as a mentor. They often come to me as an ear, someone who, for one reason or another, they are comfortable coming to me for a hearing. So in my way, I've always been involved in the life of the bar.
Commissioner Singh? Commissioner Singh?
Sorry, DCJ. Good afternoon, Advocate Mooki.
Good afternoon, Commissioner.
I was looking at your publications that you've listed here, and I was interested to see one is on forensic identification and criminal justice. Now, we know that justice is delayed due to paralyzing forensic cases. And then there's been a huge backlog in that particular department, which for some reason or other, in one quarter, the Minister of Police indicated to us that it had dramatically reduced from about 270,000 cases to 1,600. I don't know what magic wand they waved at that time to make that happen, but he told us that there were a number of additional people employed. What importance do you place on DNA and forensics in terms of the justice system?
Well, DNA would be one of the tools that will be available, should be available in the criminal justice system. The issue is how that is to be policed, given that the information that's detailed in the genes isn't only the DNA profile that is traditionally put up in the criminal system. There will be that profile in a database. There are issues about what is the integrity of the database, who has access to the database, what recourse can a person have when that material, for one reason or another, is spirited away from the database and find itself perhaps now being accessible to other parties who may want to do with that information at the time when, for example, when a buccal swab is taken, it would have been taken for a designated purpose in terms of the Criminal Procedure Act. So those are our concerns.
Yeah, the reason I'm raising this, DCJ, is, in a number of cases, particularly in GBV cases and other cases, you find that matters are delayed. And, I'm not talking about the Y chromosomes and the X chromosomes in the DA language that you know much better than all of us, but just in general forensics, because that delays a number of our cases. And what do you suggest? I mean, have you had this experience practicing as a lawyer? And what do you think we can do about it to improve that situation so that when matters get to court, and forensics is what is holding us back, that we, that department deals expeditiously with the forensic aspects so that it can help litigation and judges?
Yes, well, I imagine, Commissioner, that more fundamentally, perhaps it's a broader issue of how the police, in particular, within the criminal justice system, get to do their work. What resources do they have? Because certainly, genetic material can't be the complete answer to whatever the issue is that is being examined. So the concerns, seems to me, ought to be much broader than just what could be done with genetic material.
Thank you. And I see you've written a lot about law and technology. Do you think, from your experience, that we are up to speed with technological advancements for IR and things like that in our court systems?
I don't believe that we are as a country, and perhaps I could give an example. 20 years ago, I was looking at my papers. 20 years ago, I proposed an LLM course to one of the local universities. I proposed an LLM course on law and biotechnology, which was intended to deal with the interplay between developments in the law and biotechnology. And the university did accept my proposal as a course, but it wasn't taken up. The subject was thought very esoteric.
Thank you, Deputy Chief Justice. Thank you, Advocate Maoki.
Could I follow up on these points by Commissioner Singh? With your permission, DCJ. Mr. Moke, I feel that we're doing a disservice to the depth and the breadth of your intellectual contributions and your professional experience. I just want to put a couple of things that appear from your CV. The one is, you, as Commissioner Singh pointed out, is you've contributed scholarly pieces on DNA typing as a forensic tool. You've also contributed on intellectual property. You've also contributed on socio-economic rights. You've also written about the Truth Commission. You've also written about adjudication. You've also written about patents. It's extraordinary. So I want to ask if it is your intention to continue the scholarship when you become a judge.
Yes, very much so. I have always, I'd like to think that I've always had broad interest, and I believe that I'm a better lawyer precisely because of my other interests.
Now, just to close this agency point, I mean, it's funny, me asking you about agency, bearing in mind the fact that you are in the agent court every 2 weeks. The Rule 612 issue, I mean, you clearly are familiar with the two requirements in Rule 612, that an applicant must satisfy the court. They must set forth, I think that's the text, set forth the circumstances that render the matter urgent. And then the second one, and also explain why they cannot obtain substantial relief in due course. I mean, but your point is there's no reason to ritualistically repeat them. Any practitioner knows instinctively what they are.
Yeah, well, that's how I understood. Thank you.
Commissioner Nyembi.
Thank you, DCJ. Afternoon, Advocate.
Good afternoon, Commissioner.
My question is about access to justice. The majority of poor South Africans has got still a serious challenge when it comes to access to justice. So in your view, what do you think are the impediments when it comes to access to justice for the poor majority South Africans, especially in rural areas?
Money. The nature of the courts in terms of how they operate, how one gets to get their course through the courts, the process that is involved, and perhaps with reference to the proximity of the courts. For example, with the labor court, when there is an issue in Munsiwa, a labor issue, that person will have to come to Braamfontein. And that person most likely would have been dismissed, and perhaps unjustly so, doesn't have the means that the employer has. But before this person can get recourse, they have to enter the doors of court through all the instruments that inform how one gets to have their causes heard. Now, with this example, of course, to my mind, I don't see why the local magistrate's court in Mafikeng can't be an extension of the labor court. So then the person will not have to travel without funds from Mafikeng to Braamfontein. Those are some of the structural aspects and issues of money to do with access. And those without means suffer the most.
My last question, your worst experience as an acting judge that made you to realize that even after that worst experience, indeed you are ready for the bench?
I must confess I haven't had one. And that's not me avoiding the question. That has been my experience.
Thanks, Advocate. Thank you, DCJ.
Commissioner Clark? Oh, I thought you raised your hand earlier.
No, I did not have my hand up, DCJ. Thank you.
Sorry. Commissioner Muiman?
Thank you, DCJ. Good day, Advocate Moki.
Good afternoon, Commissioner.
Thank you. I'm just building on the first question raised by Commissioner Nyambi on access to justice. The importance of language, as part and parcel of the development, because development is communicated through language, and therefore language is also critical to the profession, to the bench. I see that on page 24 of the paginated bundle, paragraph C, you make reference to the pleading that you made in Setswana, and also that you conducted a trial in labor court in Setswana, and you didn't raise it as part and parcel of the, you didn't raise language as part and parcel of the impediment to access to language. Can you reflect on that?
Yes, it was in the back of my mind. Quite rightly, Commissioner, I have never accepted and I've never understood why the English language is given the privilege that it has in public life and in public institutions, given the country that we are. To my mind, especially when it comes to the courts, technically, there is no reason why there can't be a multiplicity of languages being used at the same time with simultaneous translations. It happens in other parts of the world. For example, the European Parliament has got 24 official languages. So when that parliament sits, a member of that parliament can use any one of the 24 languages, and other parliamentarians are able to follow right away. The technology is there. Now, of course, to my mind, it does have a bearing on whether justice has been meted or it's been carried out. There are instances where I was in a matter, medical negligence matter, and the interpreter interpreted certain aspects, which wasn't what the witness was saying. And the presiding judge wasn't alive to what was said. And I had to indicate to the court that what was being interpreted to the court isn't what the witness said. Now, of course, this was a civil matter. In the criminal courts, the risk is so much greater that a person could lose their liberties on account of interpretation. There are also time constraints. If there was simultaneous interpretations in the criminal courts, matters will run very quickly, and that will facilitate the rendering of justice. The accused would not have to spend a very long time for their matters being heard, and there have been instances where matters did not proceed because there was no interpreter. So language is important, and it can have a real effect on whether or not justice was rendered.
Thank you, Advocate Mweki. I must confess that on this one, you are on the same par with the DCJ. Thank you, DCJ.
Any questions from the colleagues on the virtual platform? I'll take your silence as consent then. All right. Mr. Mwaki, we have reached the end of your interview, sir. Thank you very much for applying for this position, and I wish you all the best. You're excused.
I'm indebted to the Commissioner. Thank you.
Hello? I can't hear properly.
Or is it the candidate? I'm sorry, voices tend to get disembodied in this room, and I got disoriented for a bit there.
Okay.
Good afternoon, Judge Mushwana.
Good afternoon, DCJ.
Are you well?
I'm very well.
All right. Are you comfortable? Can we start?
Yeah, sure.
All right. You're a labor law expert. You quite apart from your practice in that area of the law, you hold a number of academic qualifications in that field.
Yes.
You started with a BProc, then you did an LLB, and thereafter you obtained a diploma in labor law.
Yes.
And you went on to get a diploma in corporate law.
Indeed.
And you obtained an LLM in labor law.
Yes.
And you are currently doing an LLD in mercantile law.
Indeed.
How far is that process?
Well, it is at a point where I am finalizing my thesis. I'm on a chapter 4 of my thesis. Having gone through the oral examination and being approved to write the thesis. Yeah, so I'm on chapter 4, and hopefully, now that I'm on long leave, I might be able to finalize my chapters and see what happens next year.
Oh, that sounds very promising. All the best, and I take my hat off to you. I don't know how a sitting judge can do what you do, find time to study on the side as well. I couldn't do it.
Yeah, I'm told it's called sacrifice.
Of course it is. You've been, well, first you practiced as an attorney for about 22 years before your elevation to the bench.
Indeed.
What kind of work did your practice conduct?
Literally everything, I would say. And I still recall that 1995, thereabout, there was this Legal Practice Act or some act that allowed practitioners, particularly attorneys, to appear in the High Court. So I was fortunate to be amongst the first, the very first, and I did a lot of appearance in the High Court, and I did a lot of appearance in, of course, the Labor Court, the Labor Appeal Court, and the Supreme Court of Appeals.
So it was a general practice?
It was a general practice, I would say.
You acted at the Labor Court for quite some time before you were permanently appointed. Is that so?
Yes, indeed. I was almost called a permanent acting judge because I think maybe my mistake was to afford the 3 JPs that I worked with the whole term instead of just giving them a month as others would do. So I've always been in the Labor Court for a term since the time of the current Chief Justice, the Honorable Zondo.
Yeah. And I understand that you have about, well over 300 judgments out there, written judgments, that is.
Yes, I almost fainted when I saw that number because I didn't know. I never had an opportunity to count that, but it sounds right. I mean, I've been on it since 2007.
Yeah.
So it sounds correct.
Yeah, it does. Well, the fact that you've been at it since 2007 is no guarantee for anyone to produce, to be prolific. There are a few of us who've been on the bench for some time with not much to show. So.
Yes.
And some of those judgments have been upheld by the Constitutional Court.
Yes.
At first blush, your application form seems not particularly informative, and it's only when I was just going through each page that I found at the back, nestled at the very end of the form, a note which indicates that you actually sat in the High Court. You've not just been a judge in the Labor Court.
Yes, indeed.
You did a full term last year.
Yeah, I did a full term last year.
In Pretoria.
Yeah, in Pretoria.
What range of work did you do whilst there?
Well, literally I did almost everything. I even thought maybe I'm being punished by JP Mlambo because I did from criminal appeals, civil appeals, full court, special motion, urgent, and unopposed, liquidations, all the tutti, I would say I have done.
All right. Did you get an opportunity to run a trial, civil or criminal?
Yes, I did a civil trial.
Not a criminal?
No, I only dealt with criminal appeals.
Okay. The Law Society takes the view that you should spend a little bit longer in the High Court in an acting capacity before you are permanently appointed. Would you wish to comment on that?
Yeah, well, I was taken aback a little bit And I read that part almost 3 times. And for some reason, and having been listening to the interviews, it appeared as if it was a standard letter that would be churned out. But in all honesty, it seems to me that the Law Society did not take into account the fact that the Labor Court is a superior court. And it has the same status as the High Court. And having acted and also sat in the Labor Court for 6 years, I don't know what more could prepare me much more better. Particularly the Labor Court is one of the busiest court, particularly in Johannesburg. And I see my JP is here, he can confirm that. So one asks himself a question, what more experience would be required? Because if you're an acting judge, one thing you are after is to understand how to run a court. So I have run a court, I've run a motion court, I've run an agent court, I've run a trial court, and the principles are the same. So with due respect to the Law Society, I do not believe that that is a consideration for the purposes of my candidature in this city.
Yes.
I hope, I don't want to be long, but I hope I've clarified my
No,
position.
that answer suffices, at least for my own purposes. You have not listed any reserve judgments, so I take it whatever leftovers you may have are well within the acceptable norms.
Yeah, unfortunately or fortunately, I don't have leftovers. I'm enjoying my long leave.
I envy you. All right. One last thing from me. The GCB makes a comment, they raise a concern that since your appointment to, well, your elevation to the bench, you have not been involved in any community work. I'm not...
Yeah, I've seen that, and probably I ask myself what form of community work would a judge be involved in. One of my friends will always, when he sees me at weddings, he will say, you know, judges are not supposed to be with people. They're supposed to live in a mountain somewhere because of the work they do. But it seems to me that they had not obviously taken into account the community work, I would call it, that I have done before elevation. And the organizations that I belonged to before elevation. All of that I consider to be part of my community work. And additionally, I would say, and I think Judge Mlambo will bear me out, I was involved in giving a lecture for the aspirant women judges in my capacity as a judge of the Labor Court. So that I also consider to be sort of community work.
Yeah. All right, well, you get no judgment from me. I looked at your papers and I saw that you have a few young kids.
Yes.
You have been studying at breakneck speed whilst churning out good judgments. So I'm not sure what else is expected from you.
Thank you very much, DCJ.
All right, we'll stop here and give chance to the other commissioners to put questions to you.
Thank you very much, DCJ.
JP Mlambo.
Thank you very much, DCJ. Good afternoon, Judge Mshwana.
Afternoon, JP.
And is it correct that when you came to act And your presence here today is as a result of discussions between the two of us.
Indeed, it is correct.
Thank you. The DCJ has already mentioned you acted for a full term in the High Court and you were thrown in the deep end.
That's why I did mention that I thought it's a punishment. But
Well, you are a judge. You've been a judge for 6 years, so there was no need to take the precautions one takes when one appoints acting judges, isn't it?
I do appreciate that, JP.
Yes, yes. And I think your spreadsheet appears deceptively small, but simply because it just refers to the High Court exposure,
Yes.
the 9 weeks you spent there. You've been a judge for 6 years. You've done all sorts of work that a judge does, isn't it?
That's correct, JP.
Especially agent court, opposed motions. And I see you had a full court special motion whilst acting in Pretoria.
Yes, indeed.
You wrote that judgment.
I wrote a judgment and I also wrote a dissenting judgment in one of the sittings.
Yeah. So, any hardship, challenges you found doing, because you had a full judge's load. The only thing I didn't give you, and I would have taken the criticism that I wanted to kill you, had I also added opposed motions. I didn't. But in all the work you did, what's your assessment based on your experience as a sitting judge in the Labour Court?
Yeah, no, look, I did thoroughly enjoy the work at the High Court, simply because of the diversity that comes with it. But in terms of legal principles, the workload, I would say that it's almost similar to where I come from, which is the Labour Court. You would know, JP, that you've been at the Labour Court yourself. You know that it's a national court, and with a little number of judges, we do a lot of work. So it was not particularly challenging. And I can relate that during the time of the CJ as the judge president of the Labour Court, we never used to have a dedicated agent court. When you do motion court, you also do agent court. And on Wednesdays, without fail, you will leave the Labour Court after 7, after 8, because that's when you would do all sorts of unopposed and also agent court. So I would say I got used to the pressure.
Yes. So based on experience, and I can confirm, you responded to my letter that I write to all AJs that when you leave, give me a report whether you owe me anything. And you proudly said to me, I don't owe you part heads, I don't owe you judgments.
Yes, indeed.
Yeah.
Indeed.
That's based on your experience as a Labour Court judge.
Indeed, I would say so.
And you feel comfortable that you'll be able to fit in the role of a High Court judge?
Yes, I think I would transition smoothly. And I like the way the GCB puts it. It's actually a transfer, because I'm just moving from one High Court to another. But unfortunately, this process has to happen.
Yeah. Well, we all went that route. We started there.
Yes.
There are judges
I know,
in
I
all
know.
the divisions who started in the Labour Court. Yeah.
I know.
Thank you very much, DCJ. I've got no further questions.
Thank you, JP. Premier? Are you there, Premier? Okay, we'll cycle back. Minister, do you have any questions for the candidate?
Yes, DCJ, and good afternoon, Judge Mshwana.
Afternoon, Minister.
Yes, my question relates to the matter of Solomons. I see it is still on appeal, but there's a judgment in Mahube versus CCMA,
Yes.
where JP has described your decision not to grant rescission as reason defined.
Yes.
I'm not sure with the limited scope you have, because the matter is on appeal, are you able to comment on this? Because it's also an issue that the GCB is raising, that it has raised serious alarms and consternation within the labor law community.
Okay, yes, yeah, no, you're right. Obviously, if the matter is subject to an appeal process, one would not want to comment on the principles that arises in there, because another court must have an opportunity to apply its mind. Look, the Solomon's matter, just in brief, I would say I'm too surprised to hear that there's some consternation around. It just turned on the interpretation of a Section 138(5) of the Labor Relations Act. And in my own interpretation, which obviously differs to the interpretation of the JP in another matter, I considered that to say a dismissal of a matter without hearing the merits is a bit harsh. So the appropriate way to look at it will be to say, strike it off and so on. But the higher court, which is binding on me in my capacity as a labor court judge, looked at it differently. So we'll have to wait for another panel, if there is another panel that would consider interpretation.
Okay. Maybe other commissioners will take the point further. Yesterday, when we were interviewing the judges of the Labor Appeals Court, the JP was asking them that the matters they are handling and they are dealing with, and I'm now extending on the point you're traversing with the JP. And although it's in the labor court, but with the developments of labor law, it looks like those matters transverse now beyond just labor. They sometimes find themselves dealing with administrative law, insolvency law, and so forth. And I thought, as you are dealing with the JP, that you are only dealing with the matters for Gauteng High Court and so forth, what you have dealt with in the court, on the basis of the criticism that you are a labor law judge. I thought you will expand on that and tell us what is your view. Is it your view that you, in the labor court, you are no longer only dealing just purely labor, there are other matters that crops in as you deal with these complex matters that sometimes arise in the labor court?
Thank you very much, Minister. I will preface this by saying, in one conference that I attended, Conference of Judges, one of the High Court judges, when I introduced myself and said, no, I'm in the labor court, he says, oh, you the court that deals with only one contract, which is a contract of employment. And I said, no, you're mistaken. But nevertheless, this is the view that is held out there, that the labor court is very confined. But it can't be so. The starting point would be that Section 23 of the Constitution talks about fair labor practice, collective bargaining, and all sorts of things. The labor court deals with constitutional issues. The labor court deals with administrative law. The labor court deals with contractual law. The labor court, to a certain extent, would deal with what you would call a criminal work, because we deal with contempt. Those employers that are refusing to comply with the awards of the CCMA or even the orders of the court. There's an element of civil crime of contempt. So it is, as I said to the JP, it is no justification to my mind that you would say the labor court is confined, and as the DCJ at the beginning said that I'm a labor expert, but that's the view that is held there, out there rather. As the labor court, you are exposed in almost the same way, I would say, or even much more than a high court judge. So I wouldn't subscribe to the view that the labor court is only confined.
Yeah, thank you, Judge. Thank you, DCJ.
Thank you, Minister. JP Wegley. JP?
Thank you, Judge. Sorry. Thank you, DCJ. Judge Moshwanath, good afternoon.
Afternoon, JP.
I agree with everything you've said so far. I think there is this belief amongst people who don't know, who haven't practiced labor law, that labor courts are courts who are dealing with one-dimensional stuff, dismissals, unfair labor practice. If they will come there, and especially if judges from the High Court come there, they're sometimes extremely shocked at the divergent issues we have to deal with. You know, recently and over the past years, we have judges from the High Court who've come to act in the labor court. And when they left, they said they've learned so much. So you don't feel bad about anything what people say. You are perfectly fit to go to the High Court. The question is, do I want you to go there? No, that I don't want you to do. I can assure the people here that, and in fact, I don't have to say anything. It's in the reports, and the Bar Council report, I think, says that a very competent and hardworking candidate. Absolutely correct. I think the hard-working part and competence is absolutely right, because you have been there for years, and I don't think you've ever left a term with a reserved judgment. And you quite frankly, you hear matters late in the evening. If you're not hearing matters, you're actually working on a judgment. So sitting here, I'm not sure if I'm going to vote for you, but you deserve, and I'm pretty happy to say that you're one of the hardest working judges. The only issue is one pattern that's what I want to ask you is, in your questionnaire, in the very last question, I think, you've suggested that you still own shares in the law practice. I think that's a bit problematic. Hey? Is that correct, or did I read it wrong?
Oh, yes. Well, I suppose that maybe I didn't put it much more clearer. In terms of the interest, I said when I left practice, and I'm sure it could have happened to you as well, JP, that you will leave certain things, and the partners will say, no, once we get money, we'll pay you off, and so on. So it was in that context, but it is not really shares of any interest that I will always follow up and want to know what is happening.
I think you just need to sever that.
Yes.
Thank you. I have nothing further. Thank you.
DCJ, can I just... it sounds like you are going to follow up on this point.
Yeah, I was.
I wanted to follow up with the minister, but I'll come after you,
Okay,
DCJ.
it's fine. Follow up on the minister, and I'll come after.
Yes, DCJ, I think you should go first.
Okay,
I'll definitely come after you.
I was just going to clarify a little something arising from what JP Wegley said. As I understand it, it's perfectly permissible for judges to purchase shares and stocks like all other citizens. We do that as long as you declare
Yes,
what
I
you're
have.
supposed to declare in terms of the law.
Not in a law firm. It's in a law firm.
Oh, in a law firm, I missed that bit. All right, I see where the problem might be. Okay.
Yeah, okay. Okay.
All right, I withdraw my defense. Advocate Ngaitu.
Yes, well, Judge Mushwara, I think now that this point of you having a financial interest in a law firm, or potentially having one, has been raised, I think it's unfair for you to leave it hanging, because the public might think that you have a financial interest in a law firm, which would be wrong for a judge. What is the actual position, so that we don't live here thinking there's something wrong?
All right, yes. As I have explained, when you get elevated, you obviously fold, as it were, your participation in the law firm. And then you will sit around and say, look, we believe this firm is worth this much, and now that I'm leaving, it means you guys are owing me the X amount of money. And then they would say, we're going to continue with the practice, because effectively, in terms of the rules of the Law Society, I would be their practitioner, unless if I practice in a partnership, as and when I leave, I leave as an attorney for the purposes of the Law Society. But from a business point of view, my remaining partners may decide to continue with the business, and then at that point you would evaluate the business and say it's this much, and they always give you an undertaking that whenever we get money, we'll pay you out in terms of your value or your worth at the time. It's not like then it continued that you will have some form of shares in the company. It's effectively a debt. It's an acknowledgement of debt, if I may put it that way.
DCJ, can I
But
follow
what
up?
are the actual facts? I mean, I'm sorry, I don't understand. You've been a judge for 6 years, and you used to be a partner in a law firm. What's the actual factual position? I mean, you've divested, you are owed money, it will be paid. I'm not understanding what the factual position is.
Yes, the factual position is, at the time, and I'm talking 2016, 2017, thereabout, when I left practice, the practice continued, and the remaining partners said, for what is, if you were to sell this company at this point in time and take everything and go to the bench, it will be X amount of money. But because we want to continue with the practice, we will undertake to pay you that value that if you had decided to sell the firm, you would have pocketed for your own purposes before you get elevated to the bench. So those basically are the facts.
Can I follow up, DCJ? I think we need clarity here. When you look at the Legal Practice Act, because now we are no longer dealing with the Law Society.
Yes.
When you're looking at the Legal Practice Act, there's a provision there that allows practitioners to incorporate their businesses, all right? And again now, the Companies Act allows what we call personal liability companies. Now, I want to ask a direct question. The firm that you are part of, is it a partnership, as we understand a partnership to be in terms of company law, or is it a personal liability company wherein there are directors? And if there are directors, are you one of the directors? I think let us clarify that particular aspect.
All right. Thank you very much, Commissioner. The company is an incorporated PTY, as it were. I think the Companies Act allows law firms to incorporate.
It is a private company. Because
it's an incorporated law firm.
Okay, let me try to assist, because the thing is, there will be a public company, there will be a private company, that will be a PTY, and there will be a special company where people like lawyers, accountants, all those kind of people will be, which is a personal liability company. In other words, the directors are held jointly and severally liable with the company in that instance. So what I'm asking you is, the firm that you are part of, was it a personal liability company or even a private company, a PTY? Or was it a partnership in the true sense of the word as we used to understand them? And are there directors? And if there are directors, are you one of the directors? I think that will provide us with clarity.
All right. I'm not one of the directors. I resigned as a director as soon as I got elevated.
So the other directors just owe you money from your participation when you were a director?
Exactly.
Okay,
That's the point I'm making. Yes.
Then your declaration in the questionnaire is misleading, Judge Mushwana, because you categorically say directorship in my law firm, which seems to indicate that you very much remain a director there, and then you speak of remaining directors.
Yeah, I'm trying to find it. I don't know what page is it, but
It's at page 13 of the bundle.
13.
Yeah.
Yes, and maybe...
Sorry,
Whilst we
Judge
get to you,
Moshwana,
Advocate
Judge
Ngqotholo.
Moshwana, if I could just, as I understand the situation, and I think you asked me advice years and years ago, is that you sold your interests in the law firm.
Yes.
You've divested from any interest in the law firm, but they haven't paid you for your share. They owe you money, and that's being paid off. So it's really a debt. What my problem was, it's phrased very badly here in your questionnaire. It says, I own shares. You own no shares, they owe you money.
Yes.
Isn't that what it is?
That's what it
So
is.
I have a problem when you say I had an interest. You have no interest. They owe
No,
you
I
money.
have no interest.
A law firm owes you money. That's what it is.
That's what it is.
Thank
Perhaps
you.
it didn't come out as clear as it should.
Thank
and
you.
I agree and I accept that perhaps the reader would be misled and think that I'm holding shares. Our directorship in that firm, no. It's simply a question of being owed money.
To you, Commissioner Ngqotholo.
Yeah, sorry. Yeah, I think. Sorry, okay. I'm happy to consider. I just don't want. I just want to finish the point I was pursuing because it then got sidetracked with this issue of directorship. My point is not what is the corporate form. I understand there can be different corporate forms. My point is whether you have an ongoing financial interest in a law firm 6 years after you became a judge. That's my point. And I want to get that out of the way so that I don't leave the room believing that Judge Moshwana still has a financial interest 6 years after he became a judge. And that will continue when he becomes a judge of the High Court.
Yes.
So it's not the structure, whether you've resigned as a director or not, that's up to you and the declared. It's the ongoing substantive financial interest.
Yes, I think the simple answer, as the JP of the Labour Court put it and clarified, I hold no interest. I only wanted to make reference to what is still being owed, and perhaps out of caution, I had put it in that way. But effectively, I hold no interest at all, if that's what you're after.
No, Justice Moshwana. I still have a problem because the answer I understood you had given initially was that the decision or the agreement among the directors was when the firm is sold, we need to agree a price at which it will be sold. Or maybe then, if I've got that wrong, I'm terribly sorry. But maybe you can then take us through the actual steps of this nature of this relationship.
Yes, I'm going to repeat it. I said, at the time when I got elevated, I was practicing in an incorporated law firm with a number of directors. And then when I had to leave, I said, look, if I was the sole director in this firm, what will happen is that I will just simply sell this company and then pocket the money and move on. But because you want to continue with the practice, the evaluation of the practice, not the sale, the evaluation of the practice is standing at, remember the figure was 3 million at the time. Now, as a 75% shareholder at that time, it means that the remaining directors would owe me a certain amount of money. And that's how it was concluded.
Yes, but how come, because you said it's not a debt. In other words, if you had said, I'm selling you this, but you have no money to pay me now. You said it was a debt. Or I'm not understanding the relationship. Did you sell your 75% to them, and there's a sale agreement, but they are yet to pay you for that?
Yes. Yes. There was a sale, and then they yet to pay because they didn't have the money at the time.
And then what's your explanation then for the declaration? Why is there confusion with the declaration?
Well, he did say that it's clumsily phrased.
Yes.
And that's,
Yes, I apologize. You did in fact ask that question,
Yeah,
DCJ.
okay.
All right, let me stop
Are you satisfied then?
I've got the answers, DCJ.
Okay. Do you still want to follow up, Commissioner Lerotor?
Yes, DCJ. Just as an aside, after 6 years, the claim, the debt has prescribed.
When the debt is acknowledged, my little understanding of the law is that it still remains, and they have acknowledged the debt.
Commissioner,
Yeah,
yes?
CJ, I mean, I think I'm not satisfied with these answers because, but I think there's no more we can go beyond, so, but I'm really not clear about this. It seems an endless debt. I mean, we don't know. I mean, the contradiction, I understand you explain, but now you say there's a say, and it is endless. So I have a problem. I just want to draw that to your attention.
Yes.
I will argue about this matter at the
Yes.
deliberation. I'm not happy.
Thank you, Commissioner. I do appreciate and your concern, and probably I do not understand what is meant by an endless debt, but it is a debt that remains unpaid. So I don't know whether that's what you mean by endless debt.
The point is I mean, you left, when is it, 2016 or 18? But now you declare it as an interest, but to change, explanation to say, no, this is a debt. It's some years thereafter. When is it ending? What is happening? Because it means if you come back next year, you'll still be having this. I mean, I don't know. I don't have facts about this. That is my problem.
Yeah. Look, I can't take it any further than what I did in relation to the questions that emanated from various people.
Well, Commissioner Nyambi?
Thanks, DCJ. Is the very same point, but I want to put it differently. As an experienced judge of the Labour Court, the unfortunate part is that as a commission, we'll be having deliberations where you won't have that opportunity to clarify it. With the engagement, after the questions asked, do you still have the same view, or you have something that you can clarify to assist us so that when we are not part of us, we can be able to make sense and have a better understanding? Because the more we're explaining it, is the more we get confused. And if I look at the declaration in terms of what we have done in page 13 now, what is the status of what is in page 13? What is the situation currently? And the more we ask questions, the more we get confused. So it might disadvantage you if you are not clarifying us properly. So that is why I'm appealing that maybe if you can have a parting shot after the engagement, your view about what is confusing us.
As I said, and I think if there is any level of confusion, it is cleared by the fact that I had said categorically that I don't hold directorship in this firm. And all I meant to convey was to say that for some reason, maybe somebody may say, look, I come across a sale of shares and you still have an interest in this company. I thought I would explain by saying, look, I'm still being owed money. But the answer I have given is that I hold no directorship. I've been a judge since 2017. I have not had any interest in the law firm except for the fact that, acknowledging the fact that they owe me. So that's all I can say, and that's what I wanted to convey.
In your view, everything is still in order. You don't see anything wrong.
In my view, everything is still in order, and I do not see anything wrong, particularly because I have already mentioned that I hold no directorship, and I think maybe the confusion as it is written, it's written cryptically, but it sought to convey something different.
When we are saying everything is in order, we are still referring to that page 13, that what is in page 13 is still in order. We must consider it as is.
No. Page 13, I've tried to explain what it means. So I would want you to take what I have said, it means.
Thanks,
Or what
DCJ.
I sought to convey.
Thanks, DCJ.
Commissioner Singh?
Yeah, thank you, DCJ. You know, that's the point I wanted to raise on this. But I cannot agree that everything is in order, Judge Mushwana. I think everything will be in order if you can assure us that if you are recommended for appointment, you will immediately divest yourself of any interest in this law firm and also, you know, clear the ambiguity that exists, because we understand what we read. And what I read here is I still hold shares in the practice. I mean, that's what I read, and I understand that to mean you still hold shares in the practice. So are you prepared to divest yourself, if you are recommended for appointment, of any interest that you may have in your previous law firm? And I think a simple yes or no will help us in our deliberations.
Yes.
Yes.
Yes, simple answer is, to the extent that there's just lingering misunderstanding, I would simply disinvest, if at all it creates the impression. But I wanted to mention that I did state that the remaining directors were in the process of buying the shares off. So perhaps I should have just clarified that point much more further, but that's what I wanted to convey. So to the extent that it is required, and I think you should take it as my position that I will have no interest with this law firm.
No, thank you. But you see, the issue I have with the remaining directors who are in the process of buying the shares off, as raised by other commissioners, DCJ, it's 6 years. It's now 6 years. But let's leave it at that, and now that we've got this assurance. But just to JP Wagley, through you, DCJ, they say one man's gain is another person's loss. So I'll leave that thought with you. Thank you.
Thank you, Commissioner.
A follow-up there,
Yes,
DCJ.
Minister.
I think for me the point has been canvassed in terms of the time period and all that. I just want you to give insight to the public, Judge. This transition from running a firm and being called into the bench, how will you describe it for you? Because for sure, you were running a lucrative practice. You must now come into the bench with a different kind of dispensation. What motivated you to decide to leave practice and to come to the bench? And how do you describe this kind of a transition?
Okay, thank you, Minister. I think I was asked that question when I first came for the interview. I seem to recall that one of the commissioners said that I took too long to go to ascend to the bench because of having acted for almost 10 years. But the reason I heeded the call is at that time, I felt that I'm ready to provide my service to the judiciary. I wouldn't comment on the fact that I was running a lucrative practice, but granted, maybe I was. But I felt the need that my services are required at the judiciary. And here we are, 6 years later, I have, in my mind, delivered for the judiciary, and I would want to continue delivering for the judiciary.
Thank you, DCJ.
Sorry, DCJ, I'm terribly sorry. I really want to come back to this point. Justice Mushwana, when I asked the point about sale, I understood you to say you've sold. When you answered Commissioner Nyambi and Commissioner Singh, you said you were in the process of selling.
let me clarify it. I was just referencing the part in that paragraph that it didn't come out clear that what I meant to convey was at that time, given the fact that the partners or the directors did not have the money, they were in the process of buying off those shares that I left in the company. So it is not like I'm saying there is another process. I'm simply emphasizing that what I wanted to convey may appear, although ambiguously, as you may argue, in that part of the record under 21. That's what I wanted to mean.
No, but then what's there to divest? Because again, when you said, responded to Commissioner Singh, you said you undertake that you will divest.
Yes, because as I understand it, Mr. Commissioner Ngugaitobi, I understand it that it creates, even if I have explained it, it still creates an impression that I still have an interest. And to the extent, and I think Commissioner Singh has put it quite cryptly, he says that to the extent that it must not leave an impression, are you prepared to do the following? And that's the undertaking I gave.
Chief Justice, if you can allow just one. I just want to check one thing. When you apply, we were applying for your position in the labor court. Did you make a disclosure similar to that, to this one?
Commissioner Nyotesi, yes. That's why I'm saying that perhaps the way in which it came out as if it's still in 2017. So I did disclose that aspect.
Okay, before I close the subject, I'm not sure you can take it any further than you have. We'll give President Molemela a chance.
Yes, just a last follow-up to clear my understanding. The deed of sale in respect of your shares was entered into at the time when you left the firm.
Yes, that's the 2016, 2017.
Thank you.
Yes.
So to close off, Judge Mushwana, what is at paragraph 21 of page 13 of this document, which is a public document, is incorrect?
It is incorrect, sadly, perhaps given the pressures of drafting these documents, sometimes you put it in a different understanding, but it is incorrect. What it meant to convey is simply that there is still something that is being owed from my old practice.
All right. Commissioner Bernard?
DCJ, maybe to follow up on President Molemela's question. So as a result of the deed of sale, was a transfer of shares, form, or documentation completed? Or would you still be indicated on the shareholder of the company?
Is the question complete, or you still developing it, Commissioner Bernard? Before I answer.
No, it's complete. It's just, it is complete. Please answer.
Yes, no, indeed, there was a transfer of shares. It's just simply the money itself was not paid over.
Thank you, DCJ. Thank you.
Okay. I had not had hands for questions for the candidate, and all the questions that have been asked related to, they flowed from JP Wegley's question. They were follow-ups. Any questions for the candidate? No.
But does that include?
Mm-hmm.
Does that include those who are on the visual platform?
I was still coming to the colleagues on the virtual platform.
Okay.
Do you have questions? Or is that you, Commissioner Dodov? Thanks for joining us. Do you have a question?
That's correct. Yes, I do.
Go ahead.
Good afternoon, Justice Mushwana.
Afternoon. Commissioner?
My question is based on the fact that you are currently a judge at the labor court and you are flying to the High Court. And if you are appointed to the High Court, it doesn't necessarily mean that it is a loss for the labor court because the High Court also has a concurrent power that it performs in relation to labor matters like the labor court in terms of Article 7 of the Constitution. Is this how you feel?
The line was too bad, but I'm not sure whether I got everything. Assuming I did, I don't see this transition as a complete loss to the labor court. And for this reason, the labor appeal court would oftentimes draw from the judges of the High Court for the purpose of sitting in the labor appeal court. So to that extent, depending on the arrangement between the JPs, I might soon hereafter, if I'm appointed, see myself back at the labor court, but perhaps at the labor appeal court. So to the extent that it might be considered as a loss to the labor law community, I do not think it should be seen as such, given the possibility that may arise. Unless, if I didn't understand the question properly.
No, it's okay. DCJ, my line is bad. Let me go and sort it out. I'll participate in the next candidate, if possible. For now, thank you very much.
All right.
Thank you.
Thank you, Commissioner Dodov. Commissioner Wiman?
Thank you, DCJ. Good afternoon, Judge Mushwana.
Afternoon, Commissioner.
I just have one question.
Yes.
Related to your profile.
Yes.
Did you run for Law Student Council in the 90s at Wits University?
Oh, yes. That seemed to be bringing up other issues in terms of where we know each other.
Yes.
Yes, I was in the Law Student Council at Wits University in the 90s, I think, early 90s or late 90s. No, I think early 90s, rather.
Thank you, which inevitably led the basis for where you are today now. Thank you.
Thank you, Commissioner.
Is that it then, colleagues? JB?
Sorry, DCJ, I had gone out to pay rent, and I'm not sure if these questions were asked. Judge Mushwana, there are two comments made by the GCB against judgments that you wrote. You are aware of them. The first one is the Solomon's matter.
Yes.
The GCB says your judgment caused some consternation in the labor law community because the candidate held, well, they explained that you're aware of that criticism.
Yes, I'm aware, and I think it was raised already.
The question was actually raised by
yes.
Thank
JP,
you.
but for your edification, I will allow he is applying to your court in any event, so I'll allow him to
yes.
answer again.
What I said through you, DCJ, what I said, JP, was I'm surprised that the GCB sees it as a consternation. Yeah. It happens every time that the labor court would interpret a provision this way and the labor appeal court sees differently. I don't think it should be seen elevated to that high level. Yeah. But the matter, I was told by the minister, that is still under appeal. So it might well be that the Labour Appeal Court would come with a different or the same view. But the matter turned on the interpretation of Section 138(5) of the LRA, which in my view, the usage of the word dismiss in the LRA is very unfortunate, particularly in line with the Section 34 of the Constitution, that how do you dismiss a matter without hearing the merits? And
Okay, I think that's enough.
Okay.
I think, yeah. The other one, DCJ, forgive me if that was dealt with as well, but it's the Mohube matter, where the LAC said your judgment was reason defying. You are aware of that criticism?
yes,
Was that one asked?
It's related to that one.
Okay.
It's related to the Solomon's matter.
I see.
Yeah.
Okay, thank you very much, DCJ.
Was that all?
That was all, thank you.
All right. All right. Well, we're done with you, Judge Bushod.
Oh, thank you very much.
The interview has come to an end, and thank you so much for making the time.
Okay, thank you.
You're excused.
Thank you for the opportunity.
Colleagues, should we not take the lunch adjournment now? For how long? Do we take the full hour? 45 minutes. Okay, so we come back at 1:45. I'm sorry, 2:45. I'm a whole hour behind. 2:45 then. At 2:45, the candidate will be seated there. Just keep that in mind.
Good afternoon, DCJ.
How are you?
I'm fine, thank you.
All right. Well, this is not your first time in that seat, so you know the drill. You can't be nervous. Are you comfortable?
I'm comfortable, thank you.
Good. Okay. Your last interview was in October 2021.
That's correct.
For a position in this same division?
Yes.
Okay. Well, we have that on record, so I'm hoping that there won't be many questions for you. You started your career in the legal field, even if you were not a lawyer then, in the magistrates' court way back in 1974 as a clerk of the court.
Yes, that's correct.
You must have been a lad fresh from high school then.
Yes, I'm direct from the high school,
Yeah.
and then I started to work at the magistrates' court in Krugersdorp, and then I started to study through UNISA.
So you worked your way up the magistracy from clerk of the court to being a prosecutor and then became a magistrate.
That's correct, yes.
While studying on the side.
Yes.
And in that process, you obtained 4 qualifications, a deep juris and deep legum, and then you did a B juris and then an LLB.
That's correct.
All
through
part-time?
UNISA. Yes, that's correct.
Okay. You left the magistrates' court to join the bar
Yes, that was in 1994.
in 1994. So you've been at the bar since.
That's correct.
And you have been acting since 2013.
2013, that's correct.
Acting as a judge, that is. And how long? What's the cumulative?
210 weeks.
And you have a long list of judgments, written judgments, to show for all this time all those stints.
Yes, I've handed down more than 129 judgments.
Yeah.
That's apart from extempore judgments.
Yes. Well, since we have interviewed you for this very same position more than once, and we have all the vital stats, if I may call them that, on record, there does not seem to be much to ask you. What would you like to bring to the attention, well, to add to what we already have on you that has happened since October 2021?
Yes, I think what I want to highlight is that I'm very thankful to have the opportunity that JP gave me for the acting stints, and since the last time I appear here, I've gained a lot of experience, especially in civil work. When I started to act, I was doing the circuit courts, criminal courts, Western Circuit, Eastern Circuit. I've acted in Mpumalanga, and I gained quite a lot of, because my practice initially was mostly criminal work. So, but since I've been acting, I've done 90% civil work while I was acting. So I had the opportunity to cover all the areas of law. I've sat in the unopposed motions court. I sat in the opposed motions court, civil trials, in the tax court, urgent court. So yes, I've done it all.
Yeah. And you were conferred with silk in 2010?
2010, yes, I took silk.
Yeah. How old are you now? 68?
Yes, I'm 68.
Yeah.
I've turned 68 in May this year.
In May. You know, I raise this because for some, it might be seen as a bar to appointment, because if you are appointed, you wouldn't have long to serve before you actually retire.
Yes, I'm
Would
aware of that.
Yeah. What would you say to ageist who want to use your age against you?
Well, you know, to me, age is just in the mind. They said with age comes wisdom. I don't see age at this stage, my age, as an impediment to be appointed as a judge. I can still serve the judiciary for a period of 7 years, until 75 years. So I can still make a vast contribution with my experience. And yes, so I don't see age at this stage as an impediment.
And you are...
I'm healthy and...
yeah, I was going to raise that. You are in good health by all appearances.
Yes, thank you. I'm in good health. I can still, I know, you know, most of the time I've been acting here in the Gauteng division, which is a very busy division, and the workload is, it's a high workload, but I cope. I was able, throughout my stints, to deliver my judgments within 3 months. There might be one or two that was 1 day later than 3 months, but all of them were handed down within 3 months. So I'm very diligent in the work that I'm doing. I'm a hard worker, and yes, I feel that I'm very competent to do the work that as a judge.
All right, thank you very much, Mr. Stradom. I'm going to hand over to my colleagues, the other commissioners, to put questions to you. JP Mlambo.
Thank you very much, DCJ. Goedemiddag, JJ.
Good day, JP.
Hoe gaat het?
Dit gaan goed, dankie.
Gaat het goed?
Ja.
Ex-blamed at the war. Advocate Stradom, I think the DCJ has mentioned, we've interviewed you before, but you've acted a very long time. And just for it to go out there, it's not because I favor you, but you know that I call you urgently when I have a judge falls sick, because it's difficult for advocates generally to say, okay, I can come within a week's notice or whatever.
Yes.
You've been prepared to assist in that regard. That's why you have stacked up so much acting time. Yes. Am I correct?
That's correct, JP.
And the upside of this is you've done a lot of work in the heavy lifting areas. I count 7 weeks in the agent court. I count 8 weeks in the special motions court. I count 28 weeks in the opposed motions court. I count 47 weeks in criminal trials. You've actually acted in almost all the work areas, except for tax, I think. You've not done any work in the tax court. Oh, you did a week, yeah.
1 week, yes.
Yeah. So, and I'm asking you these questions to say, have you had any serious criticism, like the bar sometimes tells us, about any of the judgments you've written, especially in the special motion role, which has the complex cases?
Yes.
Have you?
No, JP, not.
Have you struggled with any of the judgments?
No. I haven't struggled with any of those judgments, and because of the experience that I gained, it was not difficult for me.
Yes.
To compile my judgments, and as you will see that I sat in full court appeals with other judges, senior judges, where in most of the times where I sat in a full court appeal, they asked me to write the judgment.
Yes.
So yes, I'm comfortable
Yeah.
in my judgment.
Let's deal with the age issue. You've effectively been acting continuously. I'll put it at 7 years. It could be higher.
Yes.
Now, you say you have another 7 years to go to 75. So there's no issue with you because you've effectively been doing the work, isn't
Yes.
it?
Yes, I'm still doing, at the moment I'm also acting, and I'm still doing the work. I was doing the urgent court in the recess. I think that's what I also want to indicate. I've submitted another schedule to just to indicate that I've also sat in the urgent court now in the last recess.
Yeah, yeah. So you don't see any challenge to you to sit in a special motion? In fact, in the latter years, the last year and the previous year, you've been acting more in Johannesburg, where there's the commercial work, and you've had no problems.
No problems.
I see. And as you say, your judgments, it's a very long list of judgments, and your industry is no doubt. So I want to thank you very much for having been available to assist the division. Thank you, DCJ. I've got no further questions.
Thank you, Judge President. Premier? We seem to have lost the Premier. Oh, you there? Do you have do you have questions for Mr. Stradom?
No, I clarified on the issue of age. Fine, thank you.
I'm sorry, I didn't catch that. Your line has become a little garbled again.
I was saying I was clarified on the age. So I'm covered. Thank you.
All right. Thank you. Minister, do you have questions? Okay. Prof. Marumachai?
Thank you very much, DCJ. Good afternoon, Judge Stradom.
Hi, good afternoon, Commissioner.
I have one question for you, which I think perhaps it may have confronted you in some of your sittings. Can a court make a determination on a dispute of fact in motion proceedings without hearing an oral evidence? If it can, yes. On what basis?
Yes, you're referring to the Plascon-Evans rule, where you can consider, you can take a robust approach also in a post-motion, but if you apply the Plascon-Evans rule, that is where you consider the evidence or the vision of the respondent and any admissions made by the applicant, and then on that basis you must decide whether you can grant the relief sought.
Thank you very much. Thank you, Deputy Chief Justice.
Commissioner King?
Thank you, DCJ. Good afternoon, Mr. Stradom.
Hi, good afternoon, Commissioner.
You may have heard the other interviews, but in them I've been giving opportunities to candidates, given the competition for only 4 spaces, to elaborate on the nature of the community-based orientation they've had in life and their involvement in bar affairs and what contribution they've made. As a long-standing member of the bar, I assume you have engaged in bar affairs and made a contribution, and this is your opportunity to just tell us about that.
Yes. Well, I was part of the lecture program. I lectured the pupils in criminal law for quite a few years. And then I was also in charge of the Prodeo. At that time, there was a Prodeo system. And I was in charge of the Prodeo system to allocate Prodeos to junior counsels for people who cannot afford a lawyer or an advocate. And then I've also done a lot of pro bono work And even now that the last recess, I was doing 1 week pro bono as a judge, acting as a judge on a pro bono basis. So yes, I think I've made a vast contribution on that aspect.
Thank you.
Any questions from the virtual platform?
Yes, please, Deputy Chief Justice, it's Glynis Breitenbach.
Yes, ask your questions, Commissioner.
Thank you, Deputy Chief Justice. Good afternoon, Mr. Strydom.
Good afternoon, Commissioner.
I must declare upfront that I know Mr. Strydom very well. We have litigated against each other many prosecutor.
Yes.
My question is not so much a question, a comment. Mr. Strydom was not only very well liked. I'm going to turn off my video to try and get better.
No, we can see you now. Oh, you disappeared again, but we can still hear you.
Okay, so is the sound better now?
Yes.
Mr. Strydom was not only a opponent, he was also a well-respected opponent, always very well prepared. The most important aspect I would like to highlight is Mr. Strydam's word was always his bond. And in criminal law, that's not only rare, but very highly prized quality.
I'm not
Thank
sure.
you.
Oh, okay. Have you finished?
Yes, thank you, Deputy Chief Justice.
Oh, thank you, Commissioner Breitenbach. I don't know if you want to say anything to the statement that was just made.
No, I can only confirm that.
So it's all true?
Yes.
All right. Commissioner Matolo Dlebo?
Thank you, Deputy Chief Justice. On a lighter note, Advocate Strydom, I see on your questionnaire you used 2 pens, the one lighter and the one darker. Was it because you were writing a lot of judgments, having to interchange your 4 pens?
I don't see any further hands, colleagues. Well, that's the end of the interview, Mr. Strydom.
Thank you.
Let me just join Judge President Mlambo in thanking you for the sterling service, your sterling service to the judiciary, and for not giving up. I hope things go your way this time, but we'll see. You're excused.
Thank you. Thank you, DCJ.
Yeah? No, yes, a good.
Thank you very much.
Good afternoon, Mr. Wanless, and welcome.
Good afternoon, DCJ. Good afternoon, Commissioners.
It's good to see you again.
Thank you.
You have a BA an LLB, and a diploma in maritime law, all obtained from the University of Natal.
That is correct, DCJ.
And you joined the bar in, was it in
December.
1990,
Correct.
after a period of about, well, a short period as a prosecutor in the NPA. Okay.
Yes, about 18 months.
Okay, so you've been at the bar since 1990.
Yes. I think that makes 33 years, if I'm not
Yes.
incorrect.
And in that 33 years, you've given the judiciary a lot of time to assist us.
Yes, DCJ, I have, and as much as it's been a pleasure to serve, and I'm very grateful for the opportunities as well that I've also been given. So it's been a two-way street.
Yes. When did you start acting as a judge?
DCJ, I started acting in 2012.
Yeah.
Yes.
And you've acted intermittently since.
Yes. Also from 2015 onwards.
Yeah. And in that time, you produced over 50 written judgments.
Yes, DCJ. I see that as this is an evolving process, and as one fills in that questionnaire and then time elapses, I think I've done another 20 odd or 30 in the short space of time from then till now. So that number has increased to probably in the 70s or 80s.
Yes. This is your fifth, according to my count, it's your fifth time appearing before this commission, applying for a vacancy in the Gauteng division of the High Court.
Yes, DCJ. It'll only be the fourth time that my name goes forward. But yes.
All right. But you were here in April.
Correct.
Yeah.
I was.
Can I just ask you to tell us in your own words why you should be appointed this time?
DCJ, again, I can only stand by, firstly, my track record, as it were, both my experience at the bar in 30-odd years of practice, and now the experience that I have been fortunate to accumulate on the bench in approximately 3 years, when one puts all that time together, 3 years of acting on the bench. Not only that, I think that my judicial temperament is well suited to the job. In that regard, there's never been any complaints or any detractions, but I've only enjoyed compliments and praise in that regard. And I think that, at the end of the day, is an extremely important aspect when one considers an appointment to the bench. As far as my diligence and my ability to work hard is concerned, I don't think that that's under any question. It never has been. I've produced all my judgments, the majority, 90-odd%, 4% thereof, and perhaps more within the stipulated guidelines of 3 months. And I think on top of that, DCJ, as a last aside, I think it's also the quality of those judgments which should perhaps be taken into account, and also perhaps when the JP question, I know we'll probably cover the type of work that I've done and the complexity thereof and the seriousness of those matters and the workload that I've carried for the division thus far.
Yes. And the attorneys and advocates, well, their representative bodies support your candidature. Everybody speaks highly of you.
Thank you, DCJ. Yes, I'm very grateful for that. I have read those reports, and I'm grateful for that support.
All right. Let's see if the other commissioners have any questions for you. JP Mlambo.
Thank you, DCJ. Hello, Advocate Wonders.
Good afternoon, JP.
We won't talk football today.
No, not today.
It's not a good week.
No, it's been a bad one.
Yeah. Like the DCJ has said, you've acted quite extensively.
Yes.
In fact, when you raised your hand to come and help is at the time when I was struggling to get silks to come in and assist in the division, and you put up your hand. That was 2015, 2016?
2015, we met, JP, so it would have been, yes, from there on.
Yeah.
Yes.
And I want to thank you for that. You've been a source of assistance. And, I mean, you've acted all that time here in Gauteng, but you've not been at a cost to the state regarding your accommodation. I want the commission to know that.
Yes.
Yeah, you've paid for your own accommodation throughout this whole period.
Yes, JP.
And you've acted in almost all the work areas, save for the tax court, which is a very specialized court.
Yes.
But you've done, I mean, in the...
I've done, JP, on that point, I've done various tax appeals. So
Yes.
it's not like I don't have any experience. I've sat on the full court.
Yes. Thank you. But I have no doubt that you've actually become a judge by default because of the long time you've had in acting. You've said 3 years cumulatively.
Yes.
And you think there's no issues with you in terms of your competence, your delivery of judgments, and no issues. You can do that.
Yes, JP. I don't think that there's any doubt. I think again the statistics prove it. From the work allocation, if I may just touch on that briefly, I'm sure you've seen the number of weeks in the opposed motion court, in the special motion court, in the family court, which is a difficult court as well. It has unopposed, opposed, and urgent matters as well. If you add those months, those weeks together, there's a considerable amount of heavy lifting, if I can use that expression again. I've covered the urgent court with, I think, competently, and all the other courts that require running civil trials. And yes, there's never been any queries raised in respect of either late judgments or, as far as I know, the quality of those judgments.
Yeah. Okay. Thank you, DCJ. I've got no further questions.
Thank you, JP. Premier, anything from you? Doesn't seem to be there.
I'm covered, DCJ. Can you hear me?
Yeah, we can hear
I'm
you.
sorry, my line is tracking.
No, we can hear you.
I'm really sorry, my line gives challenges. In the last 3 years, I've interviewed the candidate, actually the last 2 candidates, and I agree with JP that maybe this time it's an opportunity for them to be considered, and I want to add my voice on that. Thank you so much.
Thank you, Premier. Minister?
Thank you, DCJ. No, I'm covered, even on the fact that it has been a bad week for football. Because Chiefs and Arsenal lost. Thank you, DCJ.
Commissioner Merumekhe?
Thank you very much, DCJ. Good afternoon, Judge.
Good afternoon, Commissioner.
You will be sitting in a court where administrative law will be, or you are going to get cases that requires you to deal with administrative law to some extent. I'm not sure what exposure have you had and the extent to which my question will be fair, but I will ask it anyway.
Yes.
How should or can, let me put it this way, how should organ of state go about in reviewing their own decisions? What procedure should they utilize if they are looking to review their own decisions? Like an organ of state makes a decision and it finds like there's something untoward with the decision, then they want to approach the court to review their own decision. I think the Constitutional Court has given us some guidance in the case of state information technology. I'm not expecting you to have read and deal with it. I think that might be a little bit unfair, but I'm just saying, under those circumstances, what do you think that organ of state should approach that kind of an issue?
So, just to clarify, you mean in cases in that case where the organ of state is approaching the court.
Yes.
Is that correct?
To review its own decision.
Well, I must say that that's novel to me.
Oh, okay.
I've done a lot of administrative work, a lot of administrative matters, both in Johannesburg and Pretoria, but of course it's always the other way around. So I'm at loss. I can't give you a definite structure to that.
I accept that.
But I would submit in the broad sense, and without even having read that decision, I would submit in the broad sense that one should obviously apply the correct principles of administrative law. It should be in terms of PAJA. It should be that would be the first approach. And I think these days as well, with the administrative law and constitutional law having to some degree one another and some overlap, that they would obviously have to bear those principles in mind. But I can't give you a specific.
I accept that. In fact, the Constitutional Court said, look, you cannot use PAJA, you should go the legality route. Yeah, no, thank you very much. Thank you very much, DCJ.
Commissioner Nyambi.
Thank you, DCJ. Afternoon, Advocate Wenles SC on this side.
Good afternoon. Good afternoon, Commissioner.
I must also indicate and add my voice that I'm aligning myself with the Premier. So my question to you, we have had candidates in the past that come to this commission once, and then they get frustrated after leaving, we don't see them again. We are in a epitome of a candidate that shows that indeed you take this process serious and how you have conducted yourself in the past and today. A positive message that you can send to those candidates just because they appeared once and they were not recommended and then they are disillusioned, they are frustrated. That positive message that you can give to them as we are in the verge of what has been said by the Premier, as I'm aligning myself to.
Thank you, Commissioner. Yes, I'm indebted to you for those words, if they are kind words, and I appreciate that. Yes, I think if I may first of all answer from a personal point of view, and then perhaps if it's advice that it is, if I'm bold enough to give any advice to any other candidates, then I'll try to. But it's really along these lines, which is that certainly in my case, and if other candidates too have a need or a calling to serve, and that's where the starting point must be, then certainly yes, that's why I'm back again. And that's why I've continued to come back, and that's why other candidates too should, with respect, do the same thing, and not be downhearted or put off their track simply because they don't make it once or perhaps even twice. In addition to that, I've also one would soon gather, I think, that when one is nominated for this position of great importance, and one that must be taken seriously, and it must be a true commitment. So one must be sure that one is certain that one is going to do this for another 14 years. In my case, if I was elevated today, that's the time period that I have left to give is 14 years. One has to be sure that that's the kind of diligence and work ethic that one is going to maintain throughout that period. But again, if one has the nominations and the support and the nominees behind one, then one should never stop. And again, I can only bring it back to a personal perspective that I've been very, very grateful that I've been welcomed. I've said this before, that I've been welcomed in the Gauteng division in the first instance, and secondly that my nominators and my, if I may use the colloquial term, supporters in the football sense as well, that they being members of the staff, of the working staff at the courts, members of the profession, both attorneys and advocates who have appeared in my court, and the support also of my colleagues, being of all genders and race, who have spoken to me to carry on and not to throw in the towel, as it were. So those are the kinds of things. So if one finds those candidates, I think that support should be given to them, and that was something that possibly I would endeavour, wherever applicable, to do.
I really, really commend you for your positive spirit. Thank you very much. Thank you, DCJ.
Thank you, Commissioner Nyambi. Commissioner Singh?
Thank you very much, DCJ. Advocate Wanless, thank you very much.
Yes.
Perhaps if you tell us which football team you support, it could influence some of us one way or the other.
I'm afraid to do that. Yes, it's the gun. The JP and myself share a common bond in the Gunners, the Arsenal.
Okay. No further hands here. Any questions from the virtual platform?
And from us, it seems to.
All right. Well, we will end this on that note then, Mr. Wandles.
Thank you.
Thanks again
Thank you,
for not giving up on us, and I do hope I join with the others who have expressed a certain sentiment that things will hopefully go your way. You're excused.
Thank you, DCJ. I'm very grateful.
Yeah. All right, it's time for deliberations. Will those who do not belong to the Judicial Service Commission please leave the room?